Well, I may be excused for mentioning the matter which was permitted by your lordship to be listed on 11th.
No new matters, Mr. Bhattacharya. I'm
It
giving
is
you
old
leave
matter.
to move the vacation bench.
Lordship directed the matter to
Yes,
appear on
yes.
11th of May.
Yes, you come back tomorrow. I will give you leave to move the vacation bench. Yes.
As your lordship.
My lord, I am little hesitant, my lord, but my matter is very urgent, my lord.
Mr. Nag, leave to move the vacation bench. No list.
My lord, tomorrow.
No. Every matter will take 2 minutes now. I know.
My lord, very
Leave to
short.
move the vacation bench. No.
The matter is not in the list. It will be listed.
I'm giving you leave to move the vacation bench. What listed?
Only the matter is listed, lordship.
No, we shall see. You come back tomorrow. Yes.
Pardon me for mentioning, my lord. My lord, the matter is appearing in your my lord's list, my lord. Item number
Mention
53.
tomorrow. Yes.
My lord, there's some urgency, my lord. Kindly, my lord.
Who leave to move the vacation bench? Yes. Vacation bench. All vacation bench call on the list.
My lord, leave to file upon dispensation of Rule
Vacation
20.
bench. I'm giving you leave. Not here. Yes. Call on the list.
For
judgment, item number 1.
Lord's endorsement, my lord. Not there.
Mr. Ghosh, I will dictate the judgment at 11:45.
Very good.
For judgment, item number 2. Malda Construction. All 5 writ petitions. Here, who is for the petitioner? All 5 writ petitions disposed of. I'm just reading out the operative part. WPA so-and-so, 5 writ petitions are allowed for the above reasons and are disposed of with the direction on the respondents, particularly the respondent number 3 being the director, Ghanikan Chaudhary Institute of Engineering Technology, to release an amount of rupees amounts mentioned, along with security deposits furnished by the petitioners and with interest at 6% per annum on each of the aforesaid amounts from the dates on which the third and final running account bills were raised to the dates of payment. The 5 individual payments should be made by the respondents to the petitioners within 8 weeks from the date of this judgment. Item number 7. Sigma Rail System.
My lord, may I be allowed to join on virtual mode? My lord, I'm suffering from fever since last night.
Of course, you can always join on any mode to hear the judgment.
This fever, my lord.
WPA 1050 of 2023 is accordingly allowed and disposed of. By cancelling the report dated 9/11/2022 and the alleged joint report dated 10/11/2022, the respondent numbers 1, 2, and 3 are accordingly directed to commence the inspection within a period of 7 days from today, in accordance with the specification framed by the RDSO and the ATP, applying similar procedure for testing/inspection, and in the similar frequency as was being done in the 69 prior occasions before the impugned documents dated 9/11/2022 and 10/11/2022 were issued. The petitioner's equipment shall be inspected by the RDSO and the respondent number 3 within a period of 7 days as directed from the date of this judgment.
My lord, may I pray for deepest of indulgence of a stay, my lord?
Of course, you're entitled to. 1 minute.
only to that extent, my lord.
Your lordship has going to state the operation.
1 minute, 1 minute. I'm not thinking about the stay. Yes. Learned counsel appearing for the respondent railways, respondent number 1 RDSO. Praise for stay of the operation of this judgment. Stop. Considering the facts and circumstances discussed in the judgment and the proceedings for contempt initiated by the petitioners, which was shelved, SHELVED, which was shelved for hearing of the main writ petition, comma, the prayer for stay is considered and refused.
My lord, deeply obliged.
Get well soon, Mr. Ray.
I'm on
Also after,
medication.
also after the judgment.
Deeply obliged, my lord. I'm on medication, hopefully by this.
Yes.
Item number 8.
This is the bank freeze, that debit freeze will not issue.
Yes, yes. I will be dictating the judgment at 12:30.
Wait, wait.
Do we mention item number 9? Magma.
10.
Item number 10.
We could sort it out, my lord, before this side of the, this is my lord that.
Yes, yes, I remember.
My lord, kindly, my lord, put it after vacation, my lord, subject to my lord's, my lord, convenience.
That suggested
Yes, sir.
order.
Yes, that, my lord, is not, my lord, there, not, my lord, agreeable.
Yes,
So
yes.
either, my lord, we have to argue it out, or, my lord, I thought that was a way out, but perhaps, my lord, way out, my lord, for all of us, but, my lord,
Yes.
perhaps, my lord, it's, it happens. So, my lord, if it's possible, my lord, next, after vacation, immediately after vacation, my lord, I think it's, as to be mentioned, my lord, we'll try and
Yes.
for fixing of it.
Learned counsel appearing for the petitioners seeks more time, some more time
Okay.
to explore the proposed settlement between the parties. Explore the proposed settlement between the parties. Stop. List this matter on second week or third week.
Lord, first week, whatever's convenient. Lord,
First week is a holiday.
Oh, I'm sorry, 7th. I meant Lord, first week, Lord,
Yes.
after 7 June, Lord, if it's possible.
On 7 June 2023 as prayed for.
One request, my lord, that proposed, perhaps, my lord, if it's proposed settlement, my lord, if my lord, it's not recorded, my lord, then my lord, maybe
Very
better
well.
for-
Explore the what do you want? You don't want proposed.
no, my lord, not settlement at all, my lord.
Very
Because otherwise, then, my lord,
well.
get a little more sensitive to, my lord,
Ki bolam?
okay, settlement, my lord.
Some more time.
Take instructions. To take instructions, my lord.
For with regard to the suggested order handed up to the court. Stop 7th, Mr. Bhattacharya.
I'm grateful.
7 June. List this matter on 7 June 2023 as paid for.
But the suggested order is not from the side of the enforcement directorate. It is only from.
No, I've said suggested that order handed up to the court. By the petitioners.
Petition.
Grateful.
By the petitioners.
Absolutely.
Great. কাল থেকে আসছি।
Grateful.
Item number 13.
Item number 13 to 17, my
I
lord.
can't understand microphone.
My lord, item number 13 to 17, my lord, identical matters, my lord. The grievance of the petitioners, my lord, have been redressed, my lord, so they do not proceed with the case, my lord. Item
13 to
number
17. You're for
13
all
to
of them, Mr. Chatterjee?
13, 17, my lord, two of them, my lord, I am there.
13 to 17.
13,
13 to 17.
13, 14 and 17, my lord, I am for the state.
Very well. Learned counsel appearing for the petitioners 13 to 17 action করে দাও। One order is enough? Good enough?
Yes, ma'am.
কি আলাদা আলাদা করে দাও? উনি তো সব কথাতে নেই। আলাদা আলাদা করে দাও। Learned counsel appearing for the petitioners hands up a letter from the petitioner to the concerned lawyer dated 14/5/2023, which states that the grievance of the writ petitioner has been redressed by a corrigendum dated 12/5/2023. Stop. The petitioner hence does not wish to proceed with the matter. Stop. WPA 20752 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Grateful, my lord.
The letter is kept on record. আলাদা আলাদা order করে দাও।
আলাদা আলাদা করে দাও। না। Item number 18,
Your Lordship, I beg to appeal for the petitioner, Your Lordship. The grievance of the petitioner has already been redressed because the grievance of the petitioner was that he was not being allowed to get the certified copies of 2 criminal cases filed against him by the Malda Bar Association, as because he has filed numerous writ petitions
So
against.
anyway, that has been, you have.
Yes, the certified copy has already been obtained, Your Lordship.
Yes,
Just after the filing of this application.
you are appealing for whom, Mr. Ghosh?
And for the state, my lord.
Learned counsel appealing for the petitioner submits that the petitioner's grievance has already been redressed. Stop. And that the petitioner does not wish to proceed with the matter. Stop. Next, WPA 111420/2023 is dismissed as not pressed. Stop. Interim orders, if any, shall stand vacated.
Much obliged, Your Lordship.
item number 19,
This is for extension of interim order. That's matter, ESZ matter, my lord was pleased to hear.
Mr. Mukherjee?
Yes.
Are the respondents not here, Mr. Basu?
I don't find anybody today. We serve notice.
Mr. Siddiqui was there. Mr. Chatterjee was here just now.
Oh, কোথায়? পেছনে ঢুকে গেছিস কেন?
17.
Mr. Chatterjee, you choose a date, please. Usually whoever is suffering an interim order chooses the next date, please.
In
Yes.
fact, they're not suffering because they are supporting us.
Sorry,
On the affidavit, it appears they are supporting us.
supporting the,
The prisoner.
Well,
Only problem is the private respondent,
we,
not appearing at all.
we will place our stand, my lord.
very well.
Already placed.
The interim order, which is,
Maybe come back on 14th, my lord.
which is due to expire today, is extended till 30th June 2023. Stop. List this matter. When did you say?
14th June, my lord.
List this matter on 14 June 2023 as prayed for on behalf of the state.
Grateful.
Grateful, my lord.
item number 20,
May I please? My lord, this matter is coming at my instance. This matter has been listed at my instance for extension of interim order. The interim order was valid up till 19th of May 2023.
Was valid, is continuing to be
Is
valid.
continuing to be valid. It was,
Yes, Mr. Chatterjee,
Lord, will kindly extend it. Let us come back before your lordship.
the interim order is due to expire on 19th May 2023. Stop. The parties are before the court and the affidavits are complete in the matter. Stop. And affidavits are complete in the matter. Stop. The interim order is extended, next paragraph, till 30th June 2023. List this matter on. Mr. Chatterjee, when do you want to?
May we come back on 14th? Your lordship has fixed the other matter on 14th.
List this matter on 14 June 2023 as
Grateful,
prayed for
grateful.
on behalf of the state.
Oblige. Much.
Item number 21,
21, my lord, I am for the petitioner. This is for extension of interim order, my lord. Interim order is till 19th of May 2023.
Who is suffering it? The state?
Private.
My lord, I am suffering the interim order. My
You are who?
my lord, the West Bengal Transport
So
Infrastructure.
tell me when should I fix it?
My lord, 2 weeks after vacation.
The interim order granted is due to expire on 19th May 2023. Stop. Next. The parties are present and learned counsel appearing for the state respondent submits that the matter may be taken up.
Not the state respondent. She is for the transport.
My lord, I am for the Transport Corporation, my lord.
Appearing for the West Bengal Transport Corporation submits that the matter may be taken up. Which date did you say?
My lord, 2 weeks after vacation.
That the matter may be taken up 2 weeks after reopening. Stop. The interim order is extended till 30th June 2023. Is extended till 10th July 2023. List this matter on 19 June 2023 as
Grateful,
paid
my
for.
lord. Grateful.
item number 22,
Here for the petitioner. not in this.
Lordship, I'm for the respondent, Lordship, led by Mr. Shatru Banerjee. Lordship, we are ready to, for hearing this matter, Lordship. Your Lordship may kindly allow me a short pass over. Mr. Banerjee will be there, Lordship.
Hear it today and tomorrow.
Today,
Affidavits are
Lordship,
complete.
No, no, they
no,
have not
Lordship,
used it.
we will not, Lordship, in that case, use any affidavit,
You
Lordship.
will not use it.
Kindly have
I'm not willing to hear it today or tomorrow after the holidays. Tell me a date,
Lordship,
please.
Lordship.
Give me a
Lordship,
date.
then, first, the reopening, week of the reopening, Lordship, that 7th or 6th June, whatever
Very
you
well.
convenient, your Lordship.
I was praying for any day after 15th of June.
Why 15th?
And I have a leader, Mr. Mukherjee, not he's out of
Sorry,
station.
I can't understand.
Mr. SN Mukherjee, not he's leading me in the matter, but he'll be out of station.
Was he appearing in the matter?
Yes.
What is the interim order you have got?
The debarment of the petitioner for participation in tender and cancellation order of the tender has been stayed.
Coordinate bench.
Yes. And there is a subsequent development. We have used a supplementary affidavit. It's really for the purpose of creating a green corridor for a particular person. Not this has been done.
You are appearing for the state.
Lordship,
Railway
the railway
authorities.
port, Lordship, all the railway authorities, Lordship. Lordship, there is a subsequent, Lordship, we have floated the tender, for the tender, Lordship, that is actually, Lordship, restrained by your Lordship's order.
Mr. Mojumdar,
you are
I'm
suffering.
keeping it in the first week and then we shall see.
My lord.
Yes,
Same day, the date of cancellation, retendering on the same day.
yes. But if there is a continuing interim order, unless the person who is suffering wants a long date, I don't allow it.
Doesn't want to use an opposition to that.
Yes,
That's what he
that I
has
will record.
submitted.
Yes, the interim order is due to expire on, when is it expiring?
Today.
On 17th May 2023, which is today. Stop. The respondent railways, learned counsel appearing for the respondent railways submits that the railways intend to float a new tender and hence there is urgency in the matter. Stop. Next, the interim order is extended till 30th June 2023. List this matter on 8th June 2023.
Grateful, Lordship.
একটা লিখে রাখো তো council opposes the extension and submits. আর একটা লেখো council also submits that the respondents do not wish to use any affidavit in the matter.
Grateful.
item number 23,
23, my lord, I am for the respondent and led by Mr. Obrojit Mitra, my lord. For his personal, I am praying for short passover, my lord. He is on the way, my lord.
What do you mean by personal ground? Anybody who is on the way is personal
No,
ground.
no, he has gone to Mr. Arun Mondal has expired today, my lord. Foxan Mondal, Arun Mondal.
Yes.
My lord,
Tell me when I should keep the matter.
my lord,
Is it for
at-
extension?
No, my lord, this is a new matter, my lord. Yesterday, leave was granted. I'm being led by Mr. Shakoshen. He sought for the leave was granted. We have served. My lord, may take it up at 2 p.m. because if it's a personal difficulty,
Not 2 p.m.
then at whenever
At,
lordship
at
is-
12.
At 12. Grateful, my lord. Grateful.
Yes.
Item number 24.
Well,
Sure,
before
for
my
the
learned
petition.
friend starts, my lord, today morning, my lord, I have been sent a soft copy of the brief. May I come back tomorrow, my lord, to assist your lordship?
Mr. Paul, what is the urgency?
Was it tomorrow? If it's taken up tomorrow, lordship, I have no problem.
No, it's a tender matter.
Tender, my lord. Tender dates will be closing, lord, so he will have urgency, my lord. May I come back tomorrow?
Tomorrow, lordship, I have no option.
Mr. Paul, you should be forewarned that in tender matters, I usually don't give tough decisions. You should be forewarned. All right.
Lordship.
Want to try your luck or should I?
No,
should
no,
I
no,
give you
lordship.
the
Lordship,
information
tomorrow,
that-
lordship. I want to argue this case before your lordship, lordship. Then what will happen?
Very well. Learned counsel appearing for the state seeks to take instructions in the matter. Stop list this matter tomorrow as prayed for.
Grateful, my lord.
This is, lordship, affidavit of service has been, affidavit of
Affidavit of
service.
service is kept on record.
Item number 25.
My lord, with some trepidation, may I seek a very short passover? I'm being read by Mr. Bandopadhyay. He's on legs before another court, my lord. So, my lord, may I seek a very short passover, my lord, honestly.
I will be dictating two judgments in court. I don't know
I
when I'm going to
appreciate,
give
my lord,
that time.
I understand your ladyship's difficulty. Kindly accommodate me for a short passover and we'll, my lord, take that chance.
My lord has already decided the same issue in another.
Please, I'm aware of that. But I can't disallow the litigant to argue the matter
Fine.
just because I've taken a view. Yes, at 2 o'clock.
I'm so grateful.
Amen.
Item number 26.
But I appear for the petitioner.
Yes.
Matter was practically not dealt with by your lordship, Lord, directing the excise department to settle the permanent license. And Lord, by 16th of May, and your lordship had passed the interim order to continue with the temporary license till tomorrow, that is 18th May. That was the last order that your lordship had.
What was the dispute, Mr. Kaur?
The dispute was that one of the existing licensee, Lord, expired. His heirs were not cooperating. So, Lord, we came to
The co-licensee.
the co-licensee. And Lord, your lordship was pleased to, Lord, pass an order extending, Lord, the temporary license. And in the meantime,
14.6.
14.6.
Yes.
14.6 and Lord, interpretation of section 37B. Yes. And in fact, Lord, the matter was sorted out on the last day because, Lord,
So what remains of the matter, Mr. Kaur?
Lord, only thing is that we have not received the regular license as yet. So, Lord, if
So you're the creator of disturbance.
No, Your Lordship.
Yes.
As per the order, last order.
Very well.
last-
Yes, Mr. Shah, what remains of the matter?
My lord, after the intervention of your lordships, my lord, both the parties, the existing licensee and also the legal heir of the deceased licensee, both the parties have made applications jointly. We have considered, we had approved. The collector and the state government has approved their license. The only one formality is required, that is the NOC from the police department. So, my lord, what I am seeking before lordships, let the interim order be extended in the manner on the last occasion your lordships extended it. Till the time it is my lord, the regular settlement is made in their favor. My lord, until some fixed time or the
So tell me, how much time
No,
does
that is the
do these things take normally?
that is difficulties, my lord. I am right now, my lord, though I am for the state, my lord, since police is not the party, I am the representing the excise department. So lordships kindly give a direction upon the police department to issue the NOC within a certain period of time. And
Police is not a party. for
and
the
that
court.
is the difficult.
And when did you give it to the police
My lord,
for the formality?
on 12th of May.
12th May?
Hmm.
Yes,
My lord, 12th of May.
the dispute with regard to issue of a permanent license is now settled between the has now been settled between the petitioners and the respondent numbers
6 and 7.
and the private respondent numbers 6 and 7. Stop. The only procedural hitch, hitch, which remains is the NOC from the police. What police department? Police
Kolkata police, basically the
from
commissioner.
from the Kolkata police. Stop. Learned counsel, next learned counsel appearing for the excise authorities submits that the completed application was forwarded to the police on 12/5/2023. Stop. That the completed and approved application was forwarded to the police on 12/5/2023. Stop. Should I dispose of the matter, Mr.
But,
Kaur?
yes, if your lordship kindly, my lord, indicates that.
No, I will have to extend the interim order.
Yes, because my lord, or my lord, your lordship can say that interim order will continue until my lord, the license is finally settled, because they say, my lord, they have approved the final
Very
settlement.
well. WPA 2738 of 2023 is disposed of by extending the interim order to continue until the police authorities issues the NOC in favor of the petitioners and the private respondents, which shall preferably be done within by within 3 weeks. How much? 2 weeks is enough?
4 weeks, make it 4 weeks, Lord.
No,
The
within
commissioner
3
of
weeks,
Kolkata police is
within
supposed-
3 weeks from today. Or within 4 weeks, within 4 weeks from today, or earlier if the application, or within 4 weeks from today, or until the, what is the other contingency? Nothing.
Only once they get the NOC, they will issue the formal my lord, final
Very well.
license.
Or until the formal / permanent license is issued by the authorities, whichever is earlier.
Much okay.
Instead of permanent, you will also kindly use the word regular license.
Regular license is issued by the authorities, whichever is earlier.
My lord, kindly make it later, my lord, whichever is later.
Yes, right. Whichever is later.
Much okay.
Grateful, Lord.
Item number 27.
May I be permitted to recuse myself from this brief, my lord?
Recuse.
Yes, my lord. My lord, material differences as well as my lord, allegations are, my lord, leveled against me that I am elongating
I
the
can't understand what
litigation.
you're saying. Microphone, please.
My lord, material differences as well as, my lord, certain allegations are being made against me that I am elongating the litigation. My lord, I cannot in that, I am not allowed to give a no objection. So, my lord, I have no other option but to recuse myself.
No, that is only you, or there are other lawyers also in the
My lord,
matter?
my lord,
Mr. Thakkar,
yes, my lord.
Mr. Chatterjee.
Yes, Mr. Chatterjee has stopped, my lord.
What?
My lord, every time I'm explaining myself to her that I'm recusing myself, kindly take yours to another advocate. She is not listening to me. I do not.
No,
wish,
what is the dispute about?
but these are, my lord, the juniors, my lord.
No.
No, my lord.
What is the
the
dispute in the
my lord, is
petition?
her cancellation of her scheduled caste certificate. And my lord, thereafter, my lord, she was not able to obtain her admission.
Yes, Mr. Thakkar, what is the matter? You were appearing.
State respondent with Mr. Banerjee, Amitesh Banerjee.
Lord, I appeared for the petitioner. I appeared for the petitioner, my lord, and your lordship was also pleased to grant me an interim relief. Subsequently, the affidavits have been completed. But it's a pro bono matter for me, but there are some issues between the advocate on record and the client, my lord. So the advocate on record doesn't wish to continue in the matter any further, so the client can make alternate arrangements, my lord. Client is present in court, so
And the interim order is still when?
interim order is continuing, my lord. There was no. My lord, it is there is no time, my lord. It's an
Interim order dated?
the first. This is an order dated.
Yes, yes, I have it.
I'm sorry,
7th
7th
February.
February. Yes, my lord. After this, affidavits have been completed. My lord, if I may just beseech your lordship, since I cannot appear any further in the matter without instructions, my advocate.
1 minute. Yes.
I cannot appear any further in this matter, my lord, without instructions. And the attorney instructing me, my lord, does not wish to continue with the matter. Your lordship kindly keep it on the reopening date, and the client can make alternate arrangements in the meantime, my lord.
Very well. Yes.
My lord, interim order was passed, my lord, absence of my lord state. My lord, do not serve the copy of this, my lord, petitioner, my lord, without presence of ours, my lord.
You have not been served with a copy of the writ petition?
Yes,
You
my
did.
lord. Only, my lord, served, my lord.
You have not served it on the respondent?
No, my lord, I
Take out the affidavit of service, no, instead of bumbling.
My lord, after that, my lord, I got my lord, information, this order was passed, my lord, with our absence, my lord. I filed, my lord, second day, my lord, I filed, my lord, or of affidavit in opposition, my lord, totally, my lord, mislead.
Affidavits, don't argue the matter. Otherwise, I will ask you to argue till 1 o'clock. Yes. Have you filed your opposition or not?
Yes, ma'am.
Reply.
I filed my reply.
Then?
I filed my reply, my lord, because now, my lord, there is.
Yes,
because-
show me the affidavit of service, please. So you're saying you filed the opposition, then why are you saying that it's not served on you?
Address the court like
First day, my lord, got the injunction order.
Absolutely, don't waste the court's time, please. I thought you've not been served with a copy of the writ petition, an ex parte order. Affidavits are complete.
Yes, my lord, this is
Completely,
the first day, my lord,
completely.
injunction order was passed without absence of the state, my lord. The first day.
Argue the matter. Come on, argue the matter. I will hear it till 1 o'clock. Argue the matter. Come on, do it. Argue. Argue the matter.
My lord, kindly
Microphone.
have a look, affidavit in opposition, my lord.
Microphone, please. Use the
Lord,
microphone.
kindly, we have filed affidavit in opposition, my lord. On behalf
Mr.
of the-
Thakkar, if you're not willing to appear, please don't. I cannot force you to appear. Yes.
This was a pro bono brief for me, my lord, but since I was instructed by an advocate, that is why, my lord, my predicament. I have no issues.
Yes, argue the matter. Yes.
My lord.
Try all these tricks in other courts, not this court. Argue the matter. Yes.
My lord, my submission, my lord. I before your lordship, my lord, my
You are seeing that the petitioner's lawyers are in a predicament, are in difficulty.
My lord.
You are making statements as if you're trying to mislead the court that
my
you
lord.
have not been served with a copy of the writ
No, my
petition.
lord, only my lord interim order. My lord, seeking the
Very well.
interim
Yes,
order.
learned counsel appearing for the state seeks to mislead the court by giving an impression that the state respondents were not served with a copy of the writ petition.
First day of the
Stop.
hearing, my lord.
It later, however, transpires that affidavits are complete in the matter. Stop. Affidavits are complete in the matter, and the affidavit in opposition, and the state has already filed its affidavit in opposition. And naturally, that the state has already filed its affidavit in opposition. Stop. Next. The petitioner's lawyers are in a predicament since learned counsel seek to recuse from the matter on differences with the petitioner. Stop. Next. List this matter on 6 June 2023, which is the second day after reopening of the court. Stop. The interim order shall continue till 16th June 2023. The interim order is made limited till 16 June 2023. Stop. The interim order shall lapse/expire if the petitioner is not able to arrange alternative sets of counsel. Stop.
Lord, kindly, my lord, not mislead, my lord. Last day, my lord.
Next. No. Next.
No, my lord.
Let the
Kindly, my lord,
recording remain.
Not mislead the court, my lord. This is the
Let the recording
as
remain.
per instruction of my client,
No,
my
no.
lord. This is the first day, my lord. I got the brief after passing the order, my lord.
How much cost should I impose on you?
Yes, my lord. You can, my lord. My lord can impose the cost, my lord. What is the
How much cost
reality,
should
my
I
lord?
impose on you?
My lord, I submission before your lordships. My submission, my lord.
Yes, call on the next matter, please.
Item number 28.
May it please your lordship, I am for the petitioner, my lord. I am led by Mr. Kishore Datta, my lord. My lord, we have served by the affidavit and only on the day before yesterday, my lord.
Are you enjoying an interim order?
No, my lord, there are two matters, my lord. The main matters, my lord, we filed affidavit, my lord. There has been 2 days delay, my lord. You are supposed to file, my lord, by 10th, my lord. We have served.
We have received
12th,
and my
my
lord,
lord.
our
So
reply
leave
is
may be
also ready,
granted,
my lord. If your lordship kindly take this matter, my lord, tomorrow instead of today. My lord,
Why should I take up a hearing matter this side? Are you enjoying an interim order?
no, my lord. There
No,
is
my
No.
lord.
Affidavits are complete.
my lord, affidavits are
You
not
file a
yet
reply
complete.
after vacation, then I will hear the matter.
Reply is ready, my lord. I'm taking your lordship's leave to file the reply tomorrow.
Very well. I will keep the matter in June. Give me a date, please.
Yes.
Last 2 days, I will not take up these kinds of matters. Yes.
As your lordship, my lord, any day, my lord, convenient to your lordship. You know, leave may be granted to file affidavit in opposition.
You have not filed your opposition.
No, my lord, I have already served, my lord.
We have received, my lord. Our reply is also ready, my lord. My lord, if your
Yes,
lordship kindly
the
take this
affidavit in
matter
opposition
tomorrow,
is filed in court today. Stop. Learned counsel appearing for the petitioners seeks time to file the reply. Stop. List this matter. Give me a date, please, in June.
my lord, on the reopening day, if your lordship's as per your lordship's
List
convenience,
this
my lord.
matter on 6 June 2023 as prayed for. Stop. The affidavit in reply shall be filed in the course of the day.
My lord, I'm grateful.
Item number 29.
My lord, it's the same matter, my lord, because since the order of my lord debarment was there, my lord, so therefore he was not allowed to participate in the tender. So
My
it's
lord,
the same
I can
matter.
pass the
matter,
same
my
order.
lord, same order.
Yes, same order.
Leave may be granted to file affidavit.
Grateful to you.
Grateful.
Item number 30.
My lord, I am for the petitioner led by
Can't
my lord, I am for the petitioner led by Senior Advocate Tilak Basu and Arjok Dotto. Your lordship, one can has been appeared in the list, but I am not till now. I don't receive the can.
What is this, Mr. Mojumdar?
It appear for the respondent number 4. Now, this is with regard to election in a apartment ownership. And the board of managers has to be formed for the first time after
I have passed an order in this.
I mean, there is a serious dispute as regards not the writ petitioner's locus because he is not a member, he is not a flat owner. Number 1. And
No,
your
no.
lordship,
What can have you filed?
I have not filed. No,
No,
that's,
she's saying some can has been filed.
The can one can has been filed by some member of the Marlin Fifth Avenue. By they served the can through
Yes,
WhatsApp.
Mr. Mojumdar, what is the urgency in the matter? You want the order to be recalled?
only to the extent not the election has to be conducted.
Yes.
Your lordship was pleased to appoint member of the Bar Library Club for the purpose of probably making some arrangement. The last order, Mr.
Yes,
Arjun
yes,
Mukherjee.
yes, yes. Yes.
Please have a look at page 4 of your lordship's order.
Mr. Mojumdar, I can fix a time later. You can come back.
As your lordship.
My lord, kindly fix this matter after vacation, your lordship.
No. Any matter where there is an interim order, no after vacation business. If you had not got an interim order, then I would have fixed it after the vacation. Yes, Mr. Mojumdar is here.
Sir, WhatsApp service করেছে দাদাকে আমরা কোনো ফরওয়ার্ডিং আমিও রিসিভ করিনি এখনো ঠিক।
I
Yes,
believe, my
Mr.
lord, an application has been filed.
Yes, but Mr. Mojumdar says it's not by him.
We are not aware.
And
By
there's nothing in the court, in the records of the court. Mr. Mojumdar, what is it? What do you want to do? Do the matter? What is it?
My lord, so far as we, my lord, on the last occasion, my lord, your lordship was pleased to stay the meeting.
Yes.
And so far as we are concerned, my lord, we are ready with the matter. We are ready with the matter.
No, so what is the final relief you want?
My lord, the final relief, I want the order which has been passed by the competent authority is liable to be quashed. That has already been stayed.
Fixing Mr. Mojumdar's client as a person to hold the meeting?
To carry on, not down, now a special officer has been appointed, he can conduct the election or somebody, anybody from the government.
Yes.
Yes, Mr. Mojumdar?
Yes, yes.
Because under the 1972 Act, the meeting can't be held up. It has to be done.
It has to be done.
My lord, I am representing respondent number 3, the developer. We are ready with the.
Nothing.
I am representing the respondent number 3, the developer. On the last occasion, direction has been given to ready the details of all the 462 flat owners, which I can hand over to the special officer, and it is ready with me.
Very well. Mr. Mojumdar, what remains of the?
That is why I was discussing with my.
Nothing remains.
Nothing. The writ petition may be disposed of, my lord.
Yes, and I will permit, or I will direct the special officer, request the special officer to fix a date for the meeting. All right? What is the statutory time period within which it has to be fixed?
Within 15 days, the first meeting has to be called.
15 days.
15 days from what?
From the date of formation of the association.
Submission of Form 1. I
Yes. No, incorporation of the association.
Incorporation of the association.
15 days, and this is a meeting for the special general meeting,
Special general meeting,
which
whereafter
was called the extraordinary or something.
Yes.
Yes, learned counsel appearing for the parties are present, particularly the contentious parties. Stop. Next, the only thing that remains of the matter is fixing of a date for holding the special general meeting in terms of bylaw.
8.
Bylaw 8, only 8 or 8(1)?
Mother, it would be 8 as a whole. Mother, may I just take your lordship to the bylaws? 8.
No, it should be, special general meeting in terms of rule 6, bylaw 6.
Mother, it has to be 8,
Special general
8 with 6. Right?
Special
In
general
terms
meeting
of,
is in bylaw
and
6.
bylaws are of which year?
2022.
In terms of bylaws 6 and 8
Yes.
of the 2022 bylaws. Stop. Next, since a special officer, capitals, has already been appointed to
Really?
ensure communication of the since a special officer has already been appointed for this purpose by the order dated 12/5/2023, WPA 11321 of 2023 is disposed of with a request on the learned special officer to fix a date for the special general meeting,
Right.
capitals, and communicate the same in accordance with the statutory procedure contemplated under the Act, 1972 Act and the bylaws to all 462 members of the apartment complex. Stop. the special officer shall be paid an additional remuneration of rupees blank, which is to be shared by the parties in equal measure.
Only one submission. The respondent number 3, the Marling Group. They are already in possession of rupees 1 crores and not towards, not the 1 crores towards litigation expenses. Or not for the purpose of defraying all the expenses.
Litigation expenses?
For
What
the purpose
litigation?
of formation of an association and other expenses related thereto.
Yes.
If that could be
If that
shared
could be
from
mal-
that.
That is the sinking fund. That is not for the litigation purpose. That is for the association. Entire money will be deposited. Naturally,
What is a sinking fund?
But that's not before the possession is, after the possession is handed over and the association is formed, certain maintenance charges are retained by the developers. That corpus is 3 crores and odd. And 1 crore is towards litigation and other expenses for the purpose of formation and this documentation, etc.
Very well. The dispute, submissions as to the mode of payment to the special officer and the source of the funds will also be worked out by the special officer in the presence of the representatives of the parties. Stop.
Grateful, man.
It is, however, made clear that the additional remuneration shall be paid to the special officer within by 9th June 2023.
Yes, my lord. Otherwise, my lord, the meeting may not happen.
Yes.
Grateful.
All connected applications are also disposed of.
Item number 31.
Madam, for the petitioner.
But I beg for the West Bengal Information Commission.
But here, my lord, the Howrah Municipal Corporation has preferred.
I can't hear you. Speak clearly into the microphone.
My
please.
lord, here the Howrah Municipal Corporation has preferred this writ petition challenging an order passed by the West Bengal Information Commission. Your lordship, kindly come to page 33 first.
What is the can for?
There is no can in this matter.
No, there's can 1 of
Lordship,
2022.
I am on behalf of the private respondent 4, my lord.
Asking for what?
My lord, I sought one application for speedy disposal because, my lord, award has been passed by the Information Commission, which has not been complied in
Information
time.
Commission has passed an award.
Information
Directed
Commission.
the Howrah Municipal Corporation to pay a compensation of rupees 30,000.
To the private respondent.
Appellant.
Lordship, matter is that, my lord, I sought one application for RTI. That has not been replied by the municipal authority in a scheduled period of time. That's why I prefer appeal. In that appeal, that award has been passed in favor of me. That is the fact.
So it's an award under the RTI Act. They to act out.
Your lordship, kindly come to page 46, the order which is under challenge.
Right to information. Information. Doubt about it.
সরু তো পাতলা বুঝে
Yes, which under which provision?
My lord, kindly come to page 46 once of the my lord writ petition.
Which provision? Under which provision?
Lordship, that is section 19, my lord. Section 19, my lord.
Yes, which one provides
Eight.
for that award?
My lord,
Section 19(8)(b), Lordship. So far as the compensation part is concerned.
Very well. Yes, and that was for 30,000 rupees. Yes.
No, my lord,
Yes.
come to page, my lord, 33 first, the Right to Information Act application.
What is the prayer? What is your prayer?
Prayer for, my lord, because we have given sufficient explanation for such delay. Due to the non-ability of the record, we cannot provide the, my lord, information. Subsequently, it was provided. And we have, my lord, specifically intimated that what are the reasons for such delay. That has not been properly taken into consideration. The compensation has been calculated. That is also not reflected, my lord, in the order.
Page 33.
Page 33 is the, my lord, Right to Information Act application.
Yes, where is the explanation?
But that explanation has not been annexed. to
Then
the-
why are you saying that the explanation has not been taken into
But
consideration?
that has been submitted before the, my lord, Information Commission.
Absolutely no case.
But
Explanation should have been here on record.
But-
Yes, Mr. Shah.
Lord, initially, my lord, there was the commission was not satisfied at all with that. With their, my lord, so far as their explanation or whatever it is. But initially, the commission passed this order.
Where is that order?
That is at page, my lord, 5th of February. That is page 46, Lord.
Yes.
So this is the first order by the commission itself. The Chief Information Commissioner himself passed this order. That is compensation. Thereafter, they did not comply with the order. The private respondent made a complaint before the commission that in spite of the commission's order, they are not complying. So thereafter, the full bench of the commission hold seats. The 3 judges, not 3 judges, the 3 members, including the chairperson, the Chief Information Commissioner.
That is page 46.
The page 46 is the initial, first order.
Yes. And then?
They are relying upon 43. section 9.
Appellant is who?
B, Jharkhand
In page
Power.
46.
Page 46 is the first order passed by the commission.
Who is the appellant, Mr. Shah? Answer
The
the
appellant
first
is the
question.
private respondent.
Very well. Yes. Yes. And where does it say 30,000?
Kindly see the first, second, third paragraph, Lordship, page 46. Decision-টা কোথায়?
Yes. What is the basis of calculation of 30,000?
No, that is not there, my lord. Neither act says or something like that. That depends upon the, my lord, wisdom or the discretion of the commission, my lord. There is no procedure laid
And
down.
what is the delay?
But the delay was about.
So it can be 3,000 also. 3,000, 30,000, anything.
Anything.
What is the delay?
And that is not recorded here, Lordship, the delay. But they have not objected to that. But if you Lordship kindly see, they have only said who is responsible. And so far as the act is concerned.
1 minute. Yes.
On the page, but if you Lordship kindly see page 47, paginations are not there. That is the difficulty in my repetition. Page 47.
Yes.
They have stated the Howrah Municipal Corporation against whom the compensation has been awarded. Apropos the above, the undersigned would like to draw your kind attention that in your order dated 5th of February 2020, you directed the award compensation amounting to rupees 30,000 by the public authority within a period of 6 weeks under the intimation to the commission through a demand draft in the name of the appellant. But in your order, it is not clearly mentioned that who will be the responsible to pay the compensation to the appellant in this matter. So their only prayer was, contention was, that compensation is all right.
Understood. Yes. What do you have to
May I
say?
place the orders, my lord? Kindly come to page 43.
No, just tell me, what is your
Initially,
explanation?
there was commission was directed the SPIO to submit a, my lord, reply.
Yes.
SPIO submitted a reply. Thereafter, being dissatisfied, they passed an order, my lord, directed the corporation to pay an award. Corporation was never directed to submit any reply, anything about this, my lord. And the order passed is not absolutely non-speaking order, because how they have my lord, quantified this amount of 30,000, that has not been explained in the order. Now, if they finds that there was a fault on the part of the SPIO, they can proceed under section 20. there was a penalty made by, my lord.
May I submit, my lord?
Yes.
Kindly have a look, my lord, page number 47 and 46, my lord.
I've read it. I've
Led by
looked
Mr.
at it.
Banerjee.
Lordship, Howrah municipality seeking some observation, who will be the responsible authority?
Don't
And thereafter, my lord, order has been passed.
the
Sorry, my lord, I have not interfered, your lordship.
Lordship, I am
No,
placing
no
on
further.
judgment, my lord, where
Only one
19
thing, my lord.
19
I should
No,
show
no,
your
no.
lordships that we have.
who are you? Yes.
I have already given that information. Already. My lord, this sees from the annexures, my lord. Only I'm sorry, my lord, I'm drawing again. My lord, what is prayed for? Single information is prayed for.
Please listen to my order. Yes.
And 30
The petitioner, Howrah Municipal Corporation, seeks an order of restraint on the respondent appellate authority, on the respondent State Chief Information Commissioner not to give effect to an order dated 5/3/2020, dated
5th of February.
5/2/2020.
And subsequently, this order was confirmed by the
Stop.
full bench, my lord, on
All the orders has been passed by.
12th of February 2021, page 49, my lord. But unfortunately, page 48 is not there in my writ petition.
There is no full bench there.
Yes, there was full bench.
No full bench. Why
Which was confirmed.
3 members are present. No
Will you just stop it, or should I dismiss it with costs on all of you? কি বললাম? Which was subsequently confirmed by 3 members of the State Information Commissioner on 12/4/2021.
12/2, lordship.
Says dated 12/4/2021.
No, it's page 49, 12/2/2021. And 12/4 is the communication, my lord.
12/2/2021. Stop. The order was communicated on the relevant parties on 12/4/2021. Stop. By the impugned order, by the impugned orders, comma, the commission, capital C, awarded compensation of rupees 30,000 numbers to be paid by the petitioner within 6 weeks from the receipt of the order. Stop. The compensation was
19(8)B.
was directed to be paid on the authority presumably being dissatisfied with the reply to the show cause issued by the commission on the petitioner. Stop. The petitioner's reply of 5/3/2020 significantly does not question the quantum of the award, but only seeks clarification as to who will be responsible to pay the compensation. Stop. Next. The records before the court are insufficient to come to any kind of conclusion on the factual aspect of the matter. Stop. Learned counsel appearing for the parties submit that the compensation was awarded on the delay on the part of the petitioner to supply the information sought for under the provisions of the Right to Information Act, 2005. Stop. Next, the compensation, Aki paragraph, the compensation was awarded under section 8 within
Lordship, 19(8)B.
under section 19
subsection
within
8,
brackets 8 within brackets choto b, which deals with appeals, capital A, which deals with appeals and empowers the Central Information Commission to require the public authority to compensate the complainant for any loss or other detriment suffered. Stop. Next, in the present case, comma, the impugned, the first order dated 5/2/2020 of the State Chief Information Commissioner simply records that the appellant, within brackets, private respondent before the court, has submitted his written submission in respect of quantifying the claim for compensation. Stop. The commission thereafter proceeds to award the compensation of rupees 30,000 to the private respondent. Stop. There is no basis as to how the figure of 30,000 was arrived at by the State Chief Information Officer. Stop. The follow-up order of 12/2/2021 is even more bereft, B-E-R-E-F-T, bereft of reasons, and simply reiterates the order of 5/2/2020. Stop. Next. Doubtless, comma, the commission is statutorily empowered to award compensation under section 19 within brackets 8 within brackets choto b. Stop. The power conferred must, however, be accompanied by a discretion expressed through reasons. Stop. Next, WPA 13708 of 2021 is accordingly disposed of with a direction on the respondent authorities to revisit the orders dated 5/2/2020 and 12/2/2021 and pass a reasoned order on the compensation to be awarded on the petitioner. Stop. Upon considering all relevant contentions of the parties. Stop. Next. The reasoned order shall be passed within
4 weeks.
Within 3 weeks from today, and a copy of the same be made available to the petitioner as well as the private respondent before the court within a week from the date on which the reasoned order is passed.
There is some technical glitch going to the portal of the Honorable High Court. My lord, kindly give me liberty to intimate by your letter.
Intimate who?
To the information
From the
commission.
date of communication of the order, like 3 weeks from the date of
From
communication.
the date of communication.
I'm grateful.
Item number 32.
This concerns really an existential fight in the sense that there is a proposal.
Why existential?
I'll indicate to your lordship. Initially, when the jurisdiction of this honorable court with regard to company affairs was taken away and partially vested in the company law board.
Mr. Shah, you do know that the High Court is shifting to Rajarhat?
It is not. There's a stay, I understand, in respect of the property that has been requisitioned. We'll bring all those on record. We
I was
bring
just
all those-
wondering whether the writ petition will soon become infructuous. That's why.
My lord, first of all, my lord, that land, my lord, is still, my lord, absolutely vacant. Secondly, my lord, as far as I have come to learn, my lord, from one few of the retired judges of this honorable court, my lord, and your lordships will perhaps have better idea about this, is that, my lord, there is a stay on that property itself, my lord, passed by the Alipur court, because, my lord, there's some dispute with regard to title. My lord, be that as it may, my lord, kindly consider, my lord, since, my lord, the act, my lord, came into being in 1913. Now, my lord,
No, so you're sure that you don't have to file a similar writ petition in the near future for
I am reasonably certain
restraining
about
the ship back to near the Calcutta High Court?
My lord, I am reasonably sure of that, my lord.
Yes.
Your lordships, my lord, will be better informed about this, my lord. My lord, from 1913 for more than 100 years, my lord, company law, my lord, has been, my lord, practiced, decided, adjudicated upon, my lord, by the High Court till, my lord, 2016, when, my lord, the jurisdiction was virtually taken away. In spite of that, a portion of the jurisdiction is still with the High Court. My lord, I shall place section 434.
No, but I thought this is about the NCLT.
It's about NCL.
Yes.
Now, my lord, my lord, what I'm fundamentally, my lord, I'm trying to indicate to your lordships that, my lord, it is, my lord, the High Court.
So it's not an existential issue, it's a professional issue.
No, not, my lord, not really. Not really. Because, my lord, it relates to the development of law. It relates to access to justice, which are all, my lord, held to be fundamental rights.
So there are no dedicated lawyers for the NCLT?
No, my lord, nobody is dedicated.
They are all from the High Court?
Most of them, my lord. My lord, there is a bar association, my lord. We'll, my lord, give to your lordship, my lord, the names of the members, my lord, and your lordship.
Bar association of what?
Of, my lord, the NCLT. It's a registered bar association. That's the petitioner before your
And
lordship.
they're all from the High Court?
Most of them. Now, my lord, what I'm trying to indicate is 1913, my lord, Act vested the jurisdiction in the High Court. 1956 Act entirely with the High Court. Thereafter, my lord, after 1956, my lord, certain amendments, my lord, to the Act, and, my lord, portion went away, my lord, to the Company Law Tribunal. That was situated, my lord, at a distance of 20 meters from the High Court. Thereafter, my lord, after, my lord, this Act came in, my lord, the IB Code came in, and the Companies Act came in 2016, shifted, my lord, to the Town Hall area, which is
2013.
2013, my lord, and IBC came in 2016.
Yes.
My lord, in effect, my lord, the Companies Act was also given effect in 2016. It's an act of 2013 given effect, my lord, in 2016. Now, my lord, at that juncture also, my lord, it went away, my lord, to a distance of, my lord, 150 to 200 meters from the High Court. My lord, the building, my lord, which, my lord, presently houses the NCLT, my lord, is, my lord, perhaps insufficient, my lord. That is, my lord, what we have been given to understand, although we have not been consulted in any manner whatsoever.
Who is we?
My lord, the petitioner before your lordship, which is the Bar Association. Now, my lord, neither, my lord, the litigants nor, my lord, the bar.
Right to be consulted.
My lord, we don't have rights, but, my lord, it's, my lord, a process, my lord. Your lordship will kindly see if, my lord, it is shifted away, my lord, to 26 kilometers from the High Court. My lord, may I, my lord, begin by first showing to your lordship, my lord, a few photographs which we have annexed.
Photographs of the High Court?
No, my lord, photographs of, my lord, the proposed location. Kindly, my lord, take, my lord, page 46 onwards. Completely barren. I'm told it's, my lord, closer from the Bangladesh border than it is from the High Court. Completely barren, no infrastructure.
No,
no.
where is this place? Rajarhat?
My lord, it is, my lord, at the far end of Rajarhat. My lord, from the Bisho Bangla gate, my lord, it is about 20 kilometers.
So that is closer to the Bangladesh border?
No, my lord, I'm saying it's in the vicinity of the Bangladesh border. Now, my lord, your lordship will kindly, my lord, see, my lord, kindly see, my lord, complete lack of infrastructure. And they propose to, my lord, just, my lord, shift it to, my lord, at a distance of...
if it is a open field, then there will naturally be no infrastructure.
My lord, there is a building, but everything surrounding the building, my lord, is absolutely vacant. My lord, kindly have, my lord, few photographs which we've annexed from page 46 onwards. Kindly, my lord, have that.
Page 46 is the road, the Rajarhat
My lord,
road.
kindly, my lord, take, my lord, page 47, the second photograph at page 47. Page 48.
You have only snapped, clicked pictures of the road.
My lord, your lordship can, my lord, no, my lord, page 47, 48, second picture.
page 49, my lord, both pictures, 49, my lord, the second
No, what
picture.
is this house in the
My lord,
background?
They have, my lord, I'll tell you, lordship, what they've done.
No,
They have,
it's a
my lord,
multi-story
apparently
building.
constructed.
Yes. What is this picture of the house at page
My lord,
49?
that is, my lord, where, my lord, they want to shift, my lord, the NCLT.
The house.
The house. This is the house on to which, my lord, they want to shift it. Now, my lord, this, my lord, they have, my lord, they say that they are
You
building.
don't like the appearance.
I'm sorry, my lord.
You don't like the appearance of the house.
No, my lord, I don't like the location. The appearance, my lord, if I can like, my lord, the appearance where, my lord, it is presently housed, I will, my lord, like any appearance. But, my lord, the complete, my lord, inaccessibility, my lord, of the location. The fact that, my lord, lawyers who have, my lord, traditionally assisted your lordships in dispensing justice, my lord, insofar as the IB code and, my lord, the Companies Act are concerned, completely excluded. Now, my lord, access, my lord, is also, my lord, not only, my lord.
No, they will not be assisting this court. They will be assisting the NCLT.
The NCLT, my
So
lord,
how
there
will
are,
this court be deprived?
my lord, there are, my lord, some certain portions, my lord, of the Companies Act, my lord, which, my lord, still your lordships exercise jurisdiction over. It's not, my lord, no, there's not, my lord, 100%, my lord, transfer. The office of the official liquidator still, my lord, is under your lordship's jurisdiction in this court. So, my lord,
Companies Act. There are only some messy matters which remain.
yes, but it remains, my lord. There is
Yes.
an office of the official liquidator. I understand they have 100 employees. It remains, my lord, the jurisdiction still remains. It's not, my lord, been done away with. It's been curtailed heavily, my lord, but not done away with. My lord, what I'm trying to, my lord, indicate is, my lord, that, my lord, the reason why there is only one Supreme Court, my lord, housed in Delhi is because, my lord, also, my lord, accessibility to, my lord, the level of assistance, my lord, that is required.
You mean the one Supreme Court which is now encouraging virtual appearances?
My lord, Supreme Court, my lord, encourages virtual appearances, but, my lord, it is in practice, my lord, not followed. Very few
Yes.
benches, my lord, actually, my lord, permit it, as is the case, my lord, in our court. So, my lord, it is, my lord, in some
So
cases,
what happens in NCLT? No virtual appearances?
my lord, NCLT, my lord, there are some NCLTs, for example, my lord, the NCLAT.
No, no. What
Completely
about the
physical.
one which is
The one which is
supposed to be
here, my
shifted?
lord, the one which is here, my lord, virtual appearance is permitted.
Permitted.
But, my lord, your lordship will kindly see, my lord, so far as the virtual appearance is concerned, my lord, the infrastructure that we have in the High Court is not there in, my lord, the present
So it's a
NCLT.
High Court problem.
No, it's not a High Court problem, my lord. It's a problem, my lord, with regard to the NCLT. It's not a High Court.
Mr. Shaha, how is location any more a bump in the road if virtual
Yes, because,
appearances are permitted?
may I indicate, your lordship? My lord, from time to time, and my lord, we'll disclose this, my lord. I didn't know, my lord, this query would fall from your lordship, but, my lord, we should have disclosed it. My lord, from time to time, my lord, notifications are published by the president, my lord, of NCLT sitting in Delhi, my lord, who has administrative jurisdiction over all NCLTs, that, my lord, it will be made completely physical. As of today, my lord, the notification is it will be made physical. NCLTs in Ahmedabad, 100% physical. Some NCLTs in Bombay, in Delhi, 100%.
Mr. Shaha, not the concern of the court or relevant to this matter. What about the Kolkata NCLT?
My lord, Kolkata NCLT, my lord, as of now, my lord, permits, my lord, virtual hearing. But, my lord, the proper infrastructure for this virtual hearing does not exist. As a result, my lord, during the
Does not
COVID,
exist.
does not exist.
The infrastructure does not exist.
Does not exist.
Does not exist. Where, NCLT or the Calcutta High Court?
The NCLT.
NCLT.
The NCLT.
Does not exist.
Does not exist. Does not exist. Now, my lord, the manner in which, my lord, we can, my lord, address your lordships over the virtual mode, my lord, that doesn't exist over there.
So you want an upgrade in the infrastructure?
No, I don't want, my lord. I want, my lord, that there must be, my lord, a justification for suddenly, my lord, uprooting this jurisdiction and taking it, my lord, to, my lord, a destination which is 30 kilometers from this.
Mr. Shaha, I thought you said that the present NCLT building is not good enough, not sufficient to.
No, I didn't say that, my lord. The present NCLT building, my lord, is working fine. Now, my lord, they say, my lord, that there is a problem, my lord, with regard to storage of records, which there well may be. Now, my lord, we'll give to your lordship, my lord, a list of, my lord, other, my lord, facilities available, my lord, in the nearby locations, my lord, where, my lord, records can always be stored. My lord, my lord, I am not saying, my lord, even the High Court, my lord, I understand has a go down, my lord, somewhere else, my lord, in Khidirpur, my lord, to store old records. But, my lord, be that as it may, my lord, to suddenly, my lord, if the existing building, my lord, is, my lord, technically unsound, my lord, I am told, my lord, the High Court building has been condemned, my lord, for many, many years, my lord. Justice
Are,
Bhattacharya.
are you concerned about the High Court or the NCLT?
No, no, I am not. I am merely saying that, my lord, if a building which houses a court premises, which is, my lord, accessible to all lawyers, accessible to litigants, has the necessary infrastructure, has been, my lord, doing the job, my lord, from 2016 onwards. My lord, first of all, my lord, the reason
Mr.
to
Shaha, if you want, I will, whoever is appearing for yes, I will call for a report as to the existence of and the infrastructure available for virtual hearings in the NCLT. I don't think now it's a problem anymore, Mr.
My
Shaha.
lord, may I, my lord, request, my lord, today, my lord, my wish list, if your lordship will call it that, is, my lord, kindly direct them to give your lordship a report with regard to, my lord, the other facilities, my lord, available in the vicinity of maybe, my lord, the radius of 2 kilometers.
What kind of facilities?
My lord, which can house the courtroom or, my
What
lord,
kind of
records.
facilities are there in the present NCLT building, which which you apprehend will not be there in the new one?
My lord, the new one, my lord, so far as the new building is concerned, my lord, I'm not, my lord, at the moment saying, my lord, that the new building does not have, my lord, or will not have, my lord, the necessary, my lord, wherewithal, my lord, with regard to courtrooms or, my lord, with regard to infrastructure. What I'm saying is, my lord, that, my lord, it will, my lord, be completely, my lord, unfeasible, my lord, to go to a location which is 30 kilometers away. My lord, permit me to just, my lord.
Mr. Shah, you don't have to go. That's what I'm telling you. If there is virtual hearing facilities available, you don't have to go.
Yes, but, my lord, these virtual hearing facilities, my lord, kindly permit me to point out, NCLAT, 100% physical. NCLT, my lord.
Mr. Shaha, that may be the problem with NCLAT or some Ahmedabad NCLT, but that is not before me.
Yes, now, my lord.
You're only concerned about the shifting of the Kolkata NCLT.
My lord, may I indicate? Now, my lord, if I can show to your lordship that from time to time, my lord, notifications have been published that it will be completely in the physical mode.
Maybe not of concern to this court.
Yes, the Kolkata NCLT will be completely in the physical
What
mode.
about the present condition, Mr.
My lord,
Shah?
at present, my lord, it is functioning virtually, but, my lord, intermittently they make it physical. Intermittently, my lord, they make it.
So you will be happy if I say, or if I direct whoever is appearing for Mr. Trivedi, that any kind of notifications which may restrict virtual hearings or whatever, or curtail it in any form, that will not be done?
My lord, that will certainly, my lord, aid and assist the existing facility. But, my lord, that is not, my lord, the relief that we are, my lord, seeking ultimately.
What do you want? You want to,
Lord, I want
to amble along the way and have some snacks on the way also and go to the NCLT physically?
No facility for snacks really exists, my lord.
No, on the way, on the way.
No, my lord, I'm not saying that. My lord, kindly bear with me. My lord, there are one or two, my lord, legal submissions also to be made in this matter. Number one, my lord, accessibility to justice, my lord, is a fundamental right. Number one.
Whose access is being deprived or done away with? Whose access? Lawyers?
My lord, no. My lord, everybody's access.
Apart from lawyers, are you appearing for the common man or the litigants or the lawyers?
My lord, this is also, my lord, in a. Yes, my lord, there are also, my lord, your lordship will kindly see, my lord, who are the petitioners before your lordship. Kindly see, my lord.
Mr. Shah, that is all the time a very serious issue. If access to justice is being denied.
Yes.
So whose access to justice is being denied?
Everybody's, my lord.
You're only the bar association.
Litigant, workers, my lord, who are an integral part, my lord. Act second.
Workers.
My lord, workers, creditors.
Workers. So workers will be living in the Kolkata building and every day they will have to commute to Rajarhat and back.
The question is, my lord, the workers, my lord, will either, my lord, attend through lawyers. My lord, all stakeholders who are stakeholders, my lord, in an IB proceeding, or all stakeholders who are stakeholders, my lord, in a liquidation proceeding. My lord, I am not talking about, my lord.
Mr. Shaha, the concern is only for the lawyers who seek to go there physically and attend hearings.
My lord, may I, my
the
lord, try to
concern
address
does
this
not
point.
exceed beyond the lawyers. Workers, what are you saying? Workers, clerks. I am aware of the ecosystem. Ecosystem will not be denied access to justice, Mr. Shaha.
And then may I try to address this point? My lord, it is not a question of, my lord, the survival of lawyers. Although, my lord, I did start out by saying it's an existential fight. My lord, your lordship will have to, my lord, kindly consider that, my lord, if there is no, my lord, representation, my lord, by the stakeholders, my lord, if the My lord, we could have, my lord, we could have said, my lord, if my lord, there is, my lord, accessibility over video conferencing, forgive me for saying this, my lord, we could have had the court in Sundarbans today. Now, there's no need for this big high court building either. Your lordships could have sat at home, my lord, and dispensed justice equally well, which, my lord, some of your lordships were doing during the COVID period. So, my lord, there is.
So are you saying that's a good thing or a bad thing?
My lord, I'm saying it's not a feasible thing. That's why it's been discontinued. My lord, I am, my lord, only saying this. My lord, if, my lord, that is the law.
Not discontinued. It's going on quite well. It's a hybrid here. It's a hybrid system now. So lawyers who want to physically appear before the NCLT, the new building, absolutely free. Those who don't want to, virtual. What is the problem?
My lord, may I say this? My lord, my lord, the hybrid system of hearing would also then involve, my lord, portion of the lawyers appearing, my lord, physically. There is a question of filing. There is a question of accessibility of clerks. My lord, the court system doesn't work only.
So Mr. Shah, your argument is hybrid system also involves physical. Definitely. The question is of an option, the option to choose.
Yes.
If a lawyer wants to appear physically, the lawyer will travel to the new building. If the lawyer finds it not feasible, the lawyer will not travel, appear virtually. It's an option. The main thing, Mr. Shah, is the option, the right to choose what you want to do. When that right is taken away from you, that is where the court will interfere.
My lord, I understand your lordship fully. My lord, may I running commentary dile bolbo ki kore?
What do you want to do, Mr. Shah?
My lord, my lord, so far as I am concerned, my lord, I would probably have to make a choice. But like any of us.
Bag and baggage to Rajarhat.
No, my lord, that's what I, my lord, would never like to do after, my lord, so many years here. But my lord, kindly, my lord, consider this aspect of the matter. My lord, may I, my lord, develop the argument, my lord, from the very beginning.
Not from 1913. You can develop the argument for the last 2 months, not from 1913.
My lord, the argument, my lord, is this, my lord, that, my lord, the practice and procedure of law, my lord, there is synonymous, my lord, with, my lord, the involvement of lawyers. If your lordships, my lord, want to, my lord, segregate, my lord, we'll start, my lord, from the Advocates Act, my lord, when we place it finally.
1930, 1961, no. I will come back to you. Mr. Trivedi, who are you appearing for?
My lord, I am appearing for all the respondents.
Are you going to defend the move or are you going to agree with the association?
No, my lord, I am defending, my lord.
Defending?
No, my lord, I am opposing this particular prayer, my lord. Because, my lord, it's an administrative.
You're not defending the association?
My lord, I am not.
Yes. Yes.
My lord, what I have got instructions, my lord. What has fallen from my lord, if my lord directs me to file a report, my lord, I shall come back with the report because instructions.
No, what is your instruction about the infrastructure available?
Well, infrastructure is there, my lord, and it is a full-fledged building which is on the verge. It has been completed, rightly. Other ancillary things are, my lord, to be incorporated, like, and my lord, the entire company, all the offices which are associated with the company or cases, my lord, will be established there only, my lord. There will be a full-fledged hybrid system.
Offices as to?
My lord, we have got instructions, my lord. Therefore, my lord, I want to come back with my report.
And when are you proposing to shift?
Lord, as far as written instruction is concerned, my lord, we have been told that it will be between the financial year 23-24, my lord. But, my lord, I would like to come on record, my lord, by way of a report before my lord. All what I have been told, my lord, that all the departments of 23-24, my lord.
Yes.
I have been told, my lord, on instruction that all the departments of Ministry of Corporate Affairs will be stationed in that particular building. So, my lord, then, my lord, there will be ample space of records, my lord, and we have planned to establish 6 benches, my lord, but here, because of lack of space, my lord, only 2 benches are operating.
Mr. Trivedi, the most important one is the virtual hearing facilities.
My lord, it will be, my lord. It goes
because
without saying.
There has to be a balancing. I may have grilled Mr. Shah about that. I should also grill you about the infrastructure available
saying,
there.
Because that is what has fallen from the Honorable Chief Justice of India, my lord. We are all aware of that, my lord.
No,
that, my lord, virtual.
That is about virtual hearing. What is the infrastructure available with the NCLT?
We are, my lord. We are having, my lord, and we will satisfy, my lord, on that particular.
And is there any notification issue that it will be a full hearing, full physical hearing by the NCLT?
Till now, nothing has been done, my lord, what I have learned from there. Yes. My lord, therefore, my lord, but of the record, my lord, of the cup, my lord, I don't want to make any submissions, my lord. My lord will kindly direct me. We will file a report before my lord.
Saying what?
My lord, whatever falls from my lord. Whatever, my
No,
lord.
you are supposed to satisfy the court that the infrastructure exists.
My
So
lord,
what
the
kind of infrastructure?
We are shifting there to get a better infrastructure, which will be all imbibing, and it will be
Mr.
temporary.
Trivedi, don't make vague submissions. What kind of infrastructure? I'm asking you. Be specific.
My lord, I
please.
have been told, my lord, that they will be allowing virtual hearing, my lord. They will be. And there will be full infrastructure for allowing virtual hearing, my lord.
So
It will be
only
running on a
virtual hearing.
hybrid mode. It will be running on a hybrid mode. Whoever
Yes,
wants
who are the others appearing?
my lord,
Yes.
my lord, there are three respondents, my lord. There are three respondents. We are representing all.
And you propose to shift in 23-24 FY.
My lord, what I have got instructions, my lord, during the financial year, no specific date has been mentioned, my lord. But in the financial year 23-24, my lord.
And the
My lord,
building is
the
now
present-
building is now
present,
complete.
We have got the picture, my lord, pictures, my lord, which my lord so deems fit and proper, my lord. This is the building is.
Do they show anything different from the pictures already in the writ petition?
But we have got black and white pictures, and it is different, my lord, with what I could see from my.
It's the same building.
Yes, my lord, same building, but it has been completed more, my lord, because my lord kindly sees both the pictures. The portion have been. Well, it's still under construction, my lord. It has not been completed. The building has not been completed. But what I have been told, my lord, it will be equipped with all modern facilities, including internet connection and this hybrid mode of, my lord, operation of the court, my lord.
My lord, kindly see the last photograph, my lord. Second last photograph. It will give your lordship an indication, my lord, as to what is there, my lord, nearby. Nothing.
I thought you were pointing to the rubbish dump. No.
Yes, my lord, the rubbish dump, my lord, is a part of that. Your lordship will kindly see there's a nice swanky building, my lord, in the middle of nowhere. That is, my lord, the specific point that we are, my lord, making. And, my lord, they say, my lord, that they, my lord, want to bring all the buildings under one roof. My lord, so far, my lord, there's never been, my lord, any proposal, and your lordship has never seen that, my lord, the regional director, my lord, will have his office in the High Court, or, my lord, the.
How much time will you take to file the report?
My lord will kindly give us 3 weeks, my lord, because intervening vacations.
3 weeks you will have in any case, thanks to the vacation.
My lord, then
Yes.
my lord will give me 4 weeks, my lord, if it falls so, my lord. 4 weeks.
Mr. Shaha, in any case, there is, I will record the submission. There's no imminent worry
Yes, my lord,
for
23,
you to
24,
travel to Rajarhat.
Very well, my lord. 23-24, my lord.
My lord, that is, my lord, my.
Did you not know
instruction.
that? Did you not know?
Every day, my lord,
23-24?
my lord, they tell us in the NCLT, my lord, that everything is ready, my lord. My lord, the judges are going there for local inspections every day, my lord.
So the judges want to shift.
They're at least, my lord, going and seeing, my lord, what is there or not there. The members.
What is the interim relief you want?
My lord, I am praying in terms of prayer D, my lord, but since the matter is being heard by your lordship, my lord, let them not shift it in the meantime.
My
How
lord,
could they shift in the meantime? You're hearing 23-24.
Yes, my lord, if your lordship will consider, my lord, 23-20, prayer D, and my lord, kindly, my lord, pass orders having regard to the submissions made by my friend, Mr. Trivedi.
The petitioner,
my lord, I am opposing an interim order, my lord.
the petitioner number 1 is an Advocates Bar Association, capitals, of the NCLT, Kolkata bench.
May I have your
Stop.
lordship's kindly.
The other petitioners are members of that association, capital A, is that correct?
No, my lord, they are not, my lord, they are,
My lord,
my lord, they are clerks and other, my lord,
point of maintainability, my lord, should also be kept open, my lord.
The other petitioners,
are stakeholders, my lord.
the other 2 petitioners claim to be stakeholders in the process of dissemination of justice by the NCLT Kolkata bench. Stop. Next, the petitioners are essentially a group of lawyers who practice in the NCLT, Kolkata bench, and are concerned about the proposed / imminent shift of location of the Kolkata bench. Stop. The photographs annexed to the writ petition and those handed up by the learned DSG appearing for the Ministry of Corporate Affairs, comma, substantiate the apprehension, stop. The only breathing space, comma, at least by way of time, comma, is a submission made on behalf of the respondents that the proposed shift of location will be sometime in 2023-24. Stop. Next. Learned counsel appearing for the petitioners seeks to impress upon the court the continuing necessity, the continuing need to have the NCLT Kolkata bench remain in the present location, which is how many meters?
About 150 meters from the Calcutta.
Which is about 150 meters from the Calcutta High Court. Stop. Council submits that the development of company law and jurisprudence since 1913, 1913 has shown the need to keep a part of that jurisprudence within the near vicinity of the Calcutta High Court. Stop. Next, the learned DSG appearing for the Ministry of Corporate Affairs submits that the new building, comma, which is almost fully constructed, comma, has all the requisite infrastructure and facilities for physical assistance, for aiding, AIDING, for aiding the process of dissemination of justice. Stop. Council submits that the present problem of shortage of space in the current location is resolved by the new building. It is also submitted that all the connected offices of the company affairs will also be located near the new building in Rajarhat. Stop. Next.
And Millard, one more thing, Millard, this was a makeshift arrangement, Millard. It was never decided that.
Council submits that the present location was always accepted as a temporary / makeshift arrangement.
Because Millard,
Stop.
2016, when this particular act came into
Next.
effect, we had purchased that property there in 2016.
And that the new property at Rajarhat was purchased sometime in
was acquired in 2016, Millard.
Stop. Was acquired in 2016. Stop. Next. The in the present day of long distance / virtual communication, comma, any argument of lawyers being forced to physically appear before a court of law and the related difficulties associated thereto is an argument which is difficult to accept. Stop. Prima facie, comma, no, there is nothing to show. There is no evidence of record, comma, at least at this stage, comma, to show that, which would show that any of the lawyers practicing in the NCLT Kolkata bench would not be permitted to appear virtually, / online before the bench, capital B. Stop. There is also no evidence that the NCLT Kolkata bench has issued any notification to curtail the facility for virtual appearance of the lawyers. Stop. The question is one of the available, is one of option, semicolon, that is whether a lawyer who chooses to appear physically or virtually before the court has been deprived of that choice. Stop. The petitioners continue to have that option, and there is no imminent threat to the availability of that choice. Stop. Next. The Ministry of the respondents shall, however, file a report, capital R, in the form of an affidavit, lending more clarity to the existence of sufficient infrastructure in the new building, in the new proposed building, in the proposed new building. Stop. First and foremost, the availability of infrastructure with regard to virtual hearings will have to be clearly indicated. The report shall clearly indicate the availability of infrastructure for conducting virtual hearings for lawyers, so that no lawyer will be deprived of the opportunity to appear before the bench, even without having to travel physically to Rajarhat. Stop. The report shall also address the other points of concern with regard to the other stakeholders in the process, apart from lawyers, other stakeholders in the process, namely litigants and the assisting manpower who would be important, who would be indispensable for the for delivery of justice from the proposed location. Stop. Next, the report shall be filed by 9th June 2023 with an advance copy given to the petitioners. Stop.
My lord,
List this matter.
may give me a breather for a week more, my lord, instead of 9th, my lord.
By 16 June 2023 as
Written.
prayed for
In
with an
written.
advance copy to the petitioners. Stop. List this matter on 20th June, 20th June 2023.
May I make one request? My lord, instead of filing a report, my lord, let them react to this this petition by way of an affidavit. Because, my lord, I've said, my lord, that my lord, there are no train
The
stations, bus
respondents shall
stations.
also be at liberty of dealing with the writ petition in the said report by way of a separate affidavit in opposition, if the respondents so wish. Stop. Reply within.
My lord, reply within, my lord, 7 days thereafter.
Reply within 26 June 2023. Stop. List this matter on 28th June 2023.
Grateful, my lord. My lord, only one further request. My lord, from time to time, as I told your lordship, my lord, the NCLT passes, my lord, directions that it, my lord, becomes completely, my lord, physical.
Needless
My lord,
to say,
liberty to,
needless to say, comma, in light of the above. Now, in light of the above, comma, needless to say, comma, any proposed / or apprehended curtailment of the petitioners apostrophe or other stakeholders apostrophe right to virtual hearing before the Kolkata bench shall not be initiated by the respondents.
great, deeply obliged.
My lord, that is not a part of this writ petition, my lord, because and that is not being done, my lord, that is a separate issue, my lord.
Mr.
As far as-
Trivedi, that is
we are
that
not-
goes without saying. If you're going to defend your move to the to the new location, that virtual
new
hearing
location,
facility cannot be curtailed.
Milord, I am not on the new location, Milord. This is with regard to the present location, Milord.
No, no,
Very well.
because, well, it's,
This
Yes,
is with
yes.
regard to
No
present location.
curtailment of virtual hearing. You mentioned the Chief Justice of India. I'm only repeating your submissions. Yes.
grateful.
For
I'm
judgment.
indebted, my lord.
Please take back the photographs. I don't want to be entertained by these, please. Yes.
Lordship was pleased to pass over.
No, no, the judgment now. For judgment now.
For judgment, item number 1, Gaurav Rai.
I appear for the petitioners.
The petitioner claims to be the brother of his deceased sister, who passed away on 11/9/2021 and was an employee with the respondent Eastern Railways at the time of death, at the time of her passing away. Stop. The petitioner was nominated by his late sister for all service-related benefits. Stop. The petitioner also claims to be the sole and surviving heir, HEIR, of his deceased sister. Stop. The prayer in the writ petition is for declaration of Rule 549 capital A under Chapter 5, Roman 5 of the Indian Railway Establishment Code, capitals, Volume 1, prayer eta dekhe nebe, as ultra vires the Constitution of India. Stop. The petitioner prays for an injunction as by way of interim relief, comma. The petitioner prays for an injunction on the respondent railways from acting in terms of a communication dated 16/9/2022, whereby the petitioner's prayer for release of the leave encashment benefit of his deceased sister was not entertained on the ground of the issue was rejected. Stop. Next, the learned ASG appearing for the respondent railways takes a point of maintainability on the ground that the dispute raised before the court is squarely covered by sections 14 and 28 of the Administrative Tribunals Act, 1985. Stop. Council submits that the under section 3 within brackets choto q within brackets, comma, the dispute relates to a service matter which would fall under section 3 within brackets choto q of the Act, which defines all matters relating to the conditions of service in connection with the affairs of the Union or of any state or any local or other authority within the territory of India. Stop. Next. The point with regard to the issue of maintainability is being answered before going into the merits of the matter. Stop. Section 14 of the Administrative Tribunals Act, 1985 makes it deals with jurisdiction, powers and authority of the Central Administrative Tribunal, and specifically deals with recruitment and matters concerning any recruitment under subsection A, choto A of section 14. Stop. Section 14 within brackets B specifies that the jurisdiction of the tribunal, capital T, would be in matters relating to all service matters, quotation marks, concerning inter alia members of All India service, appointed in any civil service, and would include a civilian appointed to any defense services. Stop. At inter alia korda. Stop. The section hence makes it clear that the tribunal would have jurisdiction in relation to service matters, which is defined under section 3 within brackets choto q as all matters relating to the conditions of his/her service, meaning any person who has been in service and was presumably an employee, who has been in service, in connection with the affairs of the Union or of any state or any local or other authority. Stop. Section 28 relates to, provides for exclusion of jurisdiction of courts except the Supreme Court under Article 136 of the Constitution. Stop. The jurisdiction, powers and authority of the tribunal is specified under that section, under this section, in relation to recruitment and matters concerning recruitment to any service or post or service matters concerning members quotation marks of any service or persons appointed to any service or post. Stop. While member has been defined under section 3 within brackets IA, choto IA, close brackets, comma, the exclusion also relates to or persons, quotation marks, or persons, close quotation marks, which means any person, comma, who apart from a member was also in service of any of the authorities defined under section 3 within brackets choto q of the Act. Stop. Next, rule 4 within brackets 1 of the capital, the Central Administrative Tribunal within brackets procedure, close bracket rules, comma 1987, further provides for an application to be made to the tribunal, capital T, in form 1, to be presented to the tribunal in form 1I, capital I, by the applicant in person or by an agent / legal practitioner to the registrar to as specified, as provided in the prescribed form. Stop. The form I under rule 4 is in the nature of an application under section 19(19) of the Act, which relates to an application made by an aggrieved person from any order pertaining to any matter within the jurisdiction of a tribunal. Stop. The jurisdiction of a tribunal, comma, as stated above, has already been provided under section 14 of the Act. Stop. Form I indicates that the order against which the application has been made must be specified in the said form, capital F for the stop. Next. Section 20 of the Act it is relevant to point out that section 20 of the Act provides that applications need not be admitted unless all other remedies are exhausted. Stop. In the present case, comma, the petitioner before the court is the brother of the deceased employee of the respondent railways who was in service at the time of during her lifetime and at the time of her death. Stop. The petitioner before the court is hence not the person in service and thereby does not claim any benefit which would inure to the petitioner as a person who was in service with the respondent railways. Stop. The petitioner is claiming the leave encashment benefits of his deceased sister, who was the person in service with the railways. Stop. Next, this court is therefore inclined to accept the contentions made on behalf of the petitioner with reference to the maintainability of the writ petition. Stop. L. Chandrakumar versus, give me the citation, give the Puro cause director Debe. In any event, only supplanted the jurisdiction of a court under Article 226 of the Constitution and did not substitute the jurisdiction. Stop. L. Chandrakumar also did not divest the writ court of its powers under Article 226 of the Constitution. Stop. Next. With regard to the merits of the matter, stop. Mr. Ghosh. Very well, let me just get it. With regards to the merits of the matter, comma, the impugned rejection dated 16/9/2022 is an order which is ex facie without reasons. Stop. The rejection is opaque to the extent of not disclosing the basis for rejection of the petitioner's claim of his deceased sister's leave encashment benefits. Stop. The order is hence required to be. Mr. Ghosh, what remains of the writ petition?
I have sought for quashing of the rules, because if the rules stain
The order is hence required to be stayed until the matter is heard out further on affidavits. Stop. How will it benefit you, Mr. Ghosh, if I stay the order? You want the leave encashment. I am with you completely.
My lord, the ultimate relief, if I seek for the writ petition can be disposed of, my lord, if your lordship is pleased to hold that the rules as in the code, 549A in the code is, my lord, ultra.
Then I will have to decide that question. Very well. Is stayed until the matter is heard out further. Stop. On affidavit. Stop. Next, affidavit in opposition by 12 June 2023. Reply within
1 week, my lord, thereafter.
By 20th June 2023. Stop. List this matter on 22nd June 2023.
I'm so grateful. I'm grateful.
Order from the court. Yes, call on the next matter, please. Yes, the passed over matter, please.
Passover matter item number 23.
And I'm appealing for the petitioner, my lord. The petitioner, my lord, has a license for undertaking stevedoring and shore handling operations under the Kolkata Port Trust, my lord. Now, he has got a contract for unloading of iron ore as and when, my lord,
Already got a contract.
I've already got a
So what is the
I
interim,
am
what do you
only
want?
asking, my lord, I have to engage my laborers. And that because Port Trust area is a restricted entry. So I have to seek their permission for the laborers to get access to the Port Trust area. The usual practice
So
is,
why are they not getting
I
access?
do not know. My lord, they are not giving me permission. Because, my lord, there is
No, so there must be something under challenge. What is that?
I am challenging their inaction in granting me necessary permission or permit for my workers. Kindly come to page 31. These are the two mails which I have written to them, saying that I have to execute this work with the which I have got. Kindly,
What is the work?
Work is unloading of wagons, my lord.
Shore handling contract.
Yes, my lord. That is the contract also I have annexed here. Page 27 onwards.
So you're saying that the contract has been given to you by JSW Steel?
Yes.
And
But
who is
I
the
have to execute the work by.
You're the contractor.
Yes, I'm the contractor. I have to deploy workers. And that permission I require just.
Monthly permits?
Yes.
Monthly permits for what?
For these workers who will assist me in
Very well.
executing
And
the
what
work.
is their answer?
No answer.
Yes, Mr. Mitra.
Only thing, Malad, there is an unwritten rule that there are some labor contractors operating and I have to take workers from them. There is no written rule. Because Malad, the labor contractors are not providing me the labor, I have to engage my own laborers. Because the contract is mine, the headache is mine. I have to execute the contract.
No, you're saying that your laborers are not being permitted to enter the port area. That's what you're saying.
They are not giving me the permission because
I have not engaged the laborers through the labor contractor. I have engaged my own workers.
Labor contractor.
Yes.
So there's a labor contractor.
These are all unwritten. They operate in the port trust area. They provide the workers.
So what is their connection with the port trust?
Well, the port trust owes some allegiance to them, and whatever the it is only the labor contractors' workers. But I do not know, but I am saying.
Yes, Mr. Mitra, what is this?
Well, the problem is something else. Well, when there's a stevedore since they are here since 19, their problem has arisen now.
Here since?
They are the stevedores since 2019 as per the petition case. That is
They as in the petitioners.
the writ petitioner, paragraph 4, page 4.
Yes, since 2019.
From 2019 for 1 year, thereafter from November again 20. So basically from 19 onwards.
Yes.
And now they have also said at paragraph 7, page 6.
Mr. Mitra, are you permitting them to enter the port area or not?
What is required of them is we cannot allow any laborers to come in, because laborers, once they come, they don't go away. And there is union problem. I can't function because I have to provide services to everybody if their union issues arise. So, but they have to provide us the details of the laborers. We see they're not underage, and also the requirement, because
so they have not done that.
No, my lord. We have also not written. We have not written to them, but this is orally. This was communicated to them.
Mitra, then do that. Otherwise, how will they complete the work?
So I will communicate. And then also the requirement, because we can't have a
what requirement?
Well, somebody may just come in and start operating as a labor contractor inside with 400 workers. Unless they have a requirement of 400, ships are arriving. We just can't indiscriminately allow somebody with 400 workers inside. They are only to be subcontracted to our
You're saying requirement of the manpower.
Requirement of the manpower at that time, and the person's names, because there are labor contractors who are inside, who we are stuck with because for their operation.
Do that. What is the
Yes,
issue?
I will do it. But only thing is that kindly see, from 4th of May, I have written to them. I petitioned them. Point is, today the ship comes. I am not getting that permission. Then I will be penalized if I don't complete.
They have
the
not
work.
said when the ship is coming.
So
from 19, they are there.
Therefore, my lord, kindly see, from 3rd of May followed by 11th of May, they could have sent me the requirement. You give me the details of
Very
the
well.
workers.
Mr. Sen, how much time do you want to give them the particulars?
I will give them tomorrow itself.
Tomorrow?
Yes. The detailed list of the workers.
And the requirement.
And Mr. Mitra, after that, how much time do you want?
We shall consider it in the fortnight, because we must see the workers are.
No.
Why the ship will go?
Ship, well, there is no government when the ship is coming. After all,
it can come, but I can't.
Mr. Mitra, it is not a matter of whether the ship is coming or going or sailing away.
We have to take our decision.
The matter is that you have just sat over the matter since May. Why have you done that?
Since the 2nd of May, they have not said when
And
the ship is
they are the accepted contractor, not that you have a dispute with their
From
contract.
19, they are stevedores. And they have said here they are having issues with the labor force there. So, but to allow somebody else to come.
Siding with the labor.
I have to maintain peace there. I am not siding with anybody. We have to look after the peace and safety.
But your lordship kindly permit me to provide them the entire list.
And what remains of the writ petition?
Disposed of. Your lordship can dispose of the writ petition.
The issue brought to the court by the petitioners is that the petitioner number 1, despite being the contractor for certain shore handling work of the Shyama Prasad Mukherjee Port Authority, is facing difficulty, is being faced with the difficulty of its 400 workers being issued permits, monthly permits.
Not their workers. They will bring from somewhere, not their workers.
400 workers being issued monthly permits for accessing the port area. Stop. For accessing and working in the port area. Stop. Next, learned counsel appearing for the port authorities, capital P, submits that the petitioners should be called upon to provide a list of the workers with their list of the particulars of the workers, as well as the required manpower
And non-availability inside the port, that's also it.
for the work which the petitioner, for the work which is required to be done inside the port area. Stop.
And non-availability inside because they have to skip it. Because they can't flood
What
the,
non-availability?
No, that since last 4 years, they've been working with the workers. That they cannot get laborers from inside the site.
First two is enough. Next, WPA 12157 of 2023 is disposed of by directing the petitioners to provide the particulars of the list of the workers as mentioned in the petitioner's mail of 3/5/2023 to the port. By when?
And the requirements, yes.
By 6 p.m. tomorrow, i.e. 18/5/2023. Stop. The port authorities, who have remained silent after the mail of 3/5/2023, shall issue the
They should give the requirement also.
shall take requisite steps in terms of issuing the monthly permits to the workers within.
Lordship, kindly allow us to consider it because whether the
No,
requirement
no.
is there or not. Because if they don't have the requirement, if the ship is not there, so they have to indicate that the ships are being docking. Otherwise, they just can't flood the.
Will consider the list and make the decision known to the petitioners by 26th May 2023. Stop. It is made clear that the respondents shall not take any unnecessary steps to hamper the operations of the petitioners, which the petitioners have been doing, which the petitioners have been carrying on since 2019.
Obliged.
Stop.
Lordship, with the workers list, also their requirements. Lordship,
Mitra, I've said that. Read the order. I've said that. I've mentioned manpower.
I'm grateful.
Pointer ডাকো তারপরে।
Item number 33.
Mr. Ghosh, how much time will this take?
Around 10 to 15 minutes.
Then you have to come back later because I have to.
Your Lordship, I was praying for.
Microphone, please.
This matter is appearing for the first time in the list.
First time?
Yes, Your Lordship.
There has to
Yes,
be
Your
a first time.
Yes, if no objection reply date has been given.
Sorry?
Press for interim reliefs.
Very well. Mr. Ghosh, I will have to dictate a judgment and then you can come back after.
Judgment dictate করবে তারপর।
Oh, sorry. I'm
For judgment, item number 8.
The petitioner before the court is a partnership firm, is a limited liability partnership limited liability partnership firm comprising of 4 partners. 4 number, stop. The petitioner seeks a direction on the respondent Indian Overseas Bank to defreeze the bank accounts of the petitioner. The 3 bank accounts of the petitioner in the Ballygunge Park Road branch of the said bank. Stop. The dispute is between the 3 partners of the petitioner and the 4th partner, who is the respondent number 5, who is the private respondent number 5 before the court. Stop. The petitioners next, the petitioner, comma, through learned counsel, comma, submits that the action of the bank in defreezing the bank accounts of the LLP, যেখানে limited liability partner LLP করে দিও, and that too on a complaint made by the respondent number 5 on 13/3/2023 is contrary to law. Stop. Counsel submits that the petitioner or the 3 partners were not given a hearing before the impugned action of defreezing was taken by the bank pursuant to the complaint of the respondent number 5, within brackets 4th partner, close brackets. Stop. Next, learned counsel appearing for the bank, respondent bank, submits that the respondent bank acted in terms of the complaint dated 13/3/2023, dated dated 13/3/2023, and communicated the decision to debit freeze the petitioner's account to the petitioner on that day itself. Stop. Next, counsel submits that the bank is not concerned with the disputes inter se, italics দুটো আলাদা কথা, inter se between the partners. Inter se the partners, between the partners. Stop. Next, learned counsel appearing for the private respondent number 5 / the 4th partner submits that the petitioner and the remaining 3 partners have withdrawn rupees 1.7 crores as on 13/3/2023, which was not disclosed to the court. Stop. Counsel further points to minutes of meeting dated 10/3/2023 of the petitioner LLP and to agenda numbers 5 and 6 in particular, which shows that the entire income tax liability for 2020 for the assessment year 2020-21 of approximately rupees 1.50 crores was resolved to be recovered from the respondent number 5. Stop. Council submits that this and other acts on the part of the remaining 3 partners constrained the respondent number 5 to write to the bank on 13/3/2023 seeking for a debit freeze of the petitioner's bank accounts. Stop. Next. The law with regard to a unilateral debit freeze of a bank account is fairly well settled. Stop. An order passed by a division bench of this court in FMA 74 of 2020 on 7/1/2020 in FMA 74 of 2020 within brackets Reena Habiba versus the Bank of India. Stop. Specify the circumstances in which an account may be debit freezed by a bank. Stop. The circumstances include an order, an instruction from the Reserve Bank of India or a lien which the bank proposes to exercise against a constituent on the funds lying to the credit of the said constituent. Stop. The division bench was of the view that a freezing order can only be obtained from an appropriate forum and not at the instance of a constituent of the bank in the absence of the aforesaid 2 conditions. Stop. Next. In the present matter, comma, admittedly, comma, the respondent bank proceeded to debit freeze the accounts of the LLP on the complaint made by the respondent number 5. Stop. It is there is no evidence of the bank acting either in terms of a lien exercised on the funds of the petitioner's accounts or at the behest of the RBI. Stop. The act was done in pursuance of the instruction received from the respondent number 5. Stop. Next. The Respondent, same paragraph, the respondent bank has not been able to satisfy the court of the existence of any of the conditions which were mentioned in the order of the division bench. Stop. Next. This court is accordingly of the view, whatever be the disputes between the partners, and as would be evident from the minutes of meeting referred to above, comma, the respondent number 5 must approach the proper adjudicatory forum for an appropriate order of injunction on the petitioner and its partners, and the petitioner/remaining 3 partners. Stop. The bank account of the of the LLP cannot be freezed on the strength of a solitary complaint without the order of an adjudicatory forum. Stop. Next, the issue of maintainability raised on behalf of the respondent number 5 on whether the petitioner can file the writ petition, whether the petitioner, being the LLP, can file the writ petition is answered by section 3 of the Limited Liability Partnership Act, 2008, section 3 within brackets 1 of 2008, which contemplates that an LLP is a body corporate formed under the Act and is a legal entity separate and distinct from the partners. Stop. Next. WPA 8041 of 2023 is accordingly disposed of with a direction on the respondent bank to permit the petitioner to operate the bank accounts after a period of 10 weeks from today, from the date of communication of this order on the bank. Stop. The respondent number 5 shall obtain an order from a competent forum for an appropriate competent forum. In the meantime, stop. The bank, if the respondent number 5 is not in a position to do so, comma, there shall be no further fetter on the petitioner to operate the bank accounts after the period of 10 weeks as directed by the court. Stop.
Just 2 things, Lord. In your ladyship's first paragraph, your ladyship has recorded 2 accounts relating to the Baliganj Park Road. Lord, 2 accounts for Baliganj Park Road. One was Kamal Ghazi branch. So, Lord, in the very first paragraph,
Baliganj Park Road or Arakta ki Kamal Ghazi, how do you spell that?
Kamal, Kamalgazi.
Kamalgazi, one word.
My Lord, I think in usual parlance it's one word, but I'm not very sure. And my Lord, secondly, there was the issue, your ladyship will recall on the first day.
Usual parlance, it will be one word. I'm asking how do you write it?
My Lord, I'm not sure. I am not sure.
Yes.
I have to admit.
Kamal Ghazi.
And
branches.
And on the first day when this matter was taken up, I had brought to your ladyship's attention the need to make urgent statutory payments, such as, my lord, GST and electricity. My lord, we've in the affidavit in reply, we have also annexed, my lord, that chart. My lord, 10 weeks will, my lord,
8 weeks, Korodavata, 8 weeks. It is made clear that there shall be no fetter on amounts being deposited in the said accounts in the ordinary course of business of the LLP.
and my lord, if the GST payment, at least GST and electricity.
No. After 8 weeks.
Well, my lord, the LLP Act may be take back, I believe that.
Yes. Karudeda.
I'm grateful.
Yes, call on the next matter, please.
Item number 33.
For the petitioner in this matter, my lord, this relates to a second round of litigation between the petitioner.
I can't hear you. Microphone, please.
Yes, I'm on behalf of the railway authorities.
Yes.
Just now I am briefed. I'm seeking one day accommodation with your lordship.
Lord,
Is the urgency,
my
Mr.
lord,
Ghosh?
the tender has been awarded despite an earlier round of litigation where your ladyship has clearly held in our favor that a particular condition cannot be treated as an essential condition. In the second round, although they have given a reasoned order, but they've exactly done the opposite. They have acted in teeth of your lordship's order and has treated that condition.
Dispose of. Yes.
They have treated that particular condition to be an essential condition, and my lord has rejected my tender on the same ground.
When?
My lord, that has been rejected, my lord, sometime 18th of January. My lord, the writ was filed in February. My lord, we had my learned junior has mentioned a number of times. My lord,
Mr. Ghosh, January, February, you can wait till one day.
my lord, we had 1 day. I will wait. My lord, no problem. But my lord, this kindly see, my lord, 4th of May it was mentioned.
Where is the rejection? Which page?
Yes, my lord. That is, my lord, at my lord, page, my lord, 475 starts volume 3. My lord, the relevant portion 481 is, my lord, 481. 481 under the column remarks. 481 under the column remarks 2. Hence, annexure 6B certificate, which has been kept mandatory essential as per tender conditions, is important. Whereas your lordship, I'll place your lordship's order, which clearly says that this is not an essential condition. Your lordship has laid down the law, considering all the judgments of Tata Cellular and the other judgments. On this very
Which one remarks? Which one?
481 remarks, column 5, kindly come to 2.
Yes.
Hence, annexure 6B certificate, which has been kept mandatory stroke essential as per tender conditions mentioned in NIT, is important. And my lord, they have exactly, my lord, dismissed my tender on that basis. My lord, I shall take your lordship through to the order first that was passed by your lordships. My lord, very detailed order. My lord, page 469. It starts. 22nd of December, 2022. My lord, second paragraph at page 469, admitted case before the court as would be reflected for the submissions made on behalf of the parties as the petitioner's tender was rejected, as the petitioner did not upload the requisite information as per annexure 6B along with the copies of the audited balance sheets duly certified by a chartered accountant. Now, my lord, next page, respondent Eastern Railways was directed to file a report indicating the cause of the rejection. Report discloses that the only reason for the petitioner's disqualification is that the petitioner failed to upload the document under serial number 1 of the eligibility conditions. That is that certificate. The tender relates to painting of coaches of the Eastern Railways. Eligibility conditions under clause 4.
Very well. So 472 second paragraph.
472 second paragraph, my lord. Yes, 471 first paragraph, then third paragraph, my lord. Clause 18.2 of the tender document, which sets out the financial eligibility criteria requiring the tender to submit requisite information as per annexure 6B, along with the copies of the audited balance sheet duly certified by a chartered accountant, does not fall under essential conditions, so to speak. Essential conditions or mandatory requirements are always specifically categorized as such in a tender document. And then, my lord, your lordship has, my lord, considered all the clauses. Then your lordship considers Tata Cellular, lordship has considered Vidarbha irrigation, and my lord, kindly come to 473 second paragraph. Since, my lord, the time is short, my lord, 473 second paragraph, my lord. After considering Vidarbha irrigation's case, your lordship has held held that an essential condition of a tender has to be strictly complied with. Since this court is of the view that the financial eligibility criteria is not an essential condition, wither by irrigation does not assist the private respondent. In any event, this court is of the view that petitioner had uploaded all the requisite information under clause 18.2 and or such other similar clauses in the tender document before the tendering authority at the relevant point of time. The view taken by the tendering authority of the alleged non-compliance is only by reason of the information not being uploaded in the format of Annexure 6B. This is clearly rigid and technical view of the matter. Then, my lord, the railway and the private respondents have also not been able to state any particular date on and from which the private respondent has been engaged by the railways. No such evidence is furnished. My lord, all the above factors taken together persuade this court to hold that the disqualification of the petitioner on the ground stated in the reply of PIO is arbitrary and
I've read it.
now, my lord, kindly see that condition.
Mr. Ghosh, if Mr.
Let him come back tomorrow, my lord, but
But
Because
it's
if
a
it-
hard
if it-
fact, so I am too.
well, 4th May, we had mentioned the matter. Your lordship had been pleased to fix it on 17th May. Today, we have given them an email on, my lord, 11th of May, notifying that the matter has been fixed. I don't object to him coming tomorrow, my lord, but if it can be, my lord,
Appears for my
taken
London
up.
juniors, the contract has already been awarded. So, my lord, sometimes in August 2021, 22. I still.
How can it be August 2022?
August 22.
My lord,
rejection is of January.
And your lordship's order is 22nd December.
What are you saying? Your juniors are absolutely misinformed.
Right.
Yes. The rejection is of January and the contract awarded in August 2022.
Contract was awarded prior to this order. Prior to this.
Very
order.
well. Yes.
Very good.
Learned counsel appearing for the respondent railways / tendering authority seeks time to take instructions in the matter. Stop. List this matter tomorrow as prayed for.
But some, my lord, I know, my lord, I should not be making this prayer if some precedents, my lord. My lord.
What precedents?
Some, my lord,
Your the judicial precedents which you placed.
no, my lord. No, my lord, some precedents can be given. My lord, I leave it to your lordship.
Statement শুনেছো তো ম্যাডাম নামগুলো চেয়েছি ঠিক আছে কালকে ঠিক আছে কালকে রাইট টু
Five.
Lord, I am appealing.
Yes.
This judgment is just a judgment. No, I have gone through your lordship's judgment. My lord, I believe that on factually it is distinguishable. On facts.
Factual?
It is distinguishable. I will try.
Distinguishable? Yes. Up to you.
এটা আমার দাগ দেয় তো কোনটা আমার দাগ দেয়
I just thought that since I've taken a view
yes
on a particular rejection, then I should give you that chance to go to a different court.
no. But that's page page 3 of your lordship's judgment, paragraph 7.
Mr. Bandhavata, microphone, please.
Yes, ma'am.
Yes.
The impugned rejection, paragraph 7. The impugned rejection, which was communicated by a mail dated 24th April 2000, gives the reason for the rejection. The reason is that petitioner's techno-commercial bid has been found to be disqualified. In packet A, clause 12 of the tenders provide criteria on which the bidders will be evaluated in the first packet. Packet A. The criteria includes fulfillment of certain minimum eligibility conditions as stipulated in paragraph 17 of the terms. Paragraph 17 gives a tabulated statement of the category of eligible forms and supporting documents to attested copies which will have to be submitted by the eligible. Hence, even without going into whether the petitioner submitted clause 7, it is clear the 12 was an essential and mandatory terms of the tender, and further that the reason given for the petition rejection. There were 12 packet A read with 17.1. Now come to me, 12 packet, kindly come to page of my petition.
Are you for the respondents?
Well,
Which page, Mr. Bandhavata?
Page 44, my lord.
Page
44.
Page 40. 12, no, 17.
Submission.
Not 12 starts from page.
Mr. Bandhavata, you have to use the microphone.
Page 44.
42.
44 it starts.
Yes.
12. 12 submission of tenders. The tenders shall submit their offers in 2 packets in single stage. So one being technical bid and other being financial bid. Then 12 1.2, the first packet A, bidders will be evaluated on the following criteria. Whether the bidder fulfills the minimum eligibility conditions, essential / mandatory criteria and submission of relevant mandatory documents stipulated in para 17 below. Whether the proposed plan of GST fulfills the minimum infrastructural facilities, so and so. Now, kindly come to 17.1. Kindly come to page 47. 17.1. First is page 46. Minimum eligible criteria, eligible firms. Yes. 17.1. Essential eligible criteria. Then page 47, 17.2. This is the essential eligible criteria. Applicants shall have at least 2 years experience in manufacturing, transportation or logistics and related business. 1. 2 is net worth of the applicant shall be at least 50% to be established cost of construction as per the minimum infrastructural facilities determined by the railways. These are the 2 essential eligible criteria. Now, so far 1 is concerned, applicants shall have at least 2 years experience.
Yes.
Malad, kindly come to page 85 to 88.
Yes.
Page 85 to 88.
Yes.
That your lordships will find. Page 85. 10 years experience. '86, 10 years experience. 85 and 86 same, sorry. 87. Another 10 years, this is also 10 years experience. These are the experience they're having. So far, kindly come back to page 47 again. Net worth.
net worth of the applicant shall be at least 50% of the estimated cost. What is the estimated cost? Miller, kindly come to page 37. Point 3.
Page
37, my lord. The estimated cost which has been indicated, 50%. I'm first showing estimated cost. Estimated cost of project work, 21 crores 11 lakhs 75,077.
Yes.
Then 50% of this net worth has to be kept. Kindly come to Miller, page 137. Audit from the audited balance sheet, page 137.
Yes.
Page 137, kindly see balance sheet as on 31st March 2022.
Yes.
Kindly similar, extra right hand side bottom 100 crores 35 lakhs 69 to 216. So I'm having criteria, and your lordship will also read clause 18 along with that 17.2. That's at page 47. Kindly similar page 47, 18.2. Your lordship kindly see. The first packet A, shall be with the objective of scrutinizing the capability, financial strength, experience, etc. of the tenders. The technical bids will contain the following information: complete set of tender documents, along with the certificate, credentials, support of fulfillment, earnest money, copy partnership deed, layout plan. It's there. All the documents are there. And Miller, just a show to your lordships one thing, Miller, kindly come to the documents which had been. Format to page down. Yes. Miller, kindly come to page 67. Details of the tenders. Page 68. This is their format. One is constitution of the firm. Partnership firm is given. 2 full name individuals to the AM enterprise has been given documents. 3 documents in support of constitution of the firm submitted. 4 year of formation incorporated 2001. Name of property directors given. Other number 6 given. 7 PAN number has been given. Also 8, 9, 10, 11, 12 is there.
So what is the arbitrariness, Mr. Bandyopadhyay?
Other?
Arbitrariness.
Arbitrariness is this rejection of this one. My lord, I don't know from the, although your lordships have come to these findings in this judgment, no reason is required to be given. But unless I know even rejection.
I don't say that. Supreme Court says that now.
Your lordships have followed that. Therefore, now your lordship is saying.
Yes.
Your lordships have followed that. Therefore, I'm saying your lordship said that. My lord, kindly consider one thing. Supreme Court is supreme. I have nothing to say. Page 165.
Yes.
Your techno-commercial bid against tender number so-and-so has been found technically unsuitable due to the following reasons. Comments disqualified in packet A. But I have shown to your lordships the qualifications which are required in packet A. Now, how do I infer? What is the reason? How do I infer? How do I come to learn? How?
No, packet A.
Packet A, I have shown.
Yes.
Packet A.
There was something wrong with whatever documents you gave in packet A.
Well, therefore, something has to be added along with this. This reason is not a sufficient reason.
Mr. Bandyopadhyay, that part I have already taken a view in my judgment.
Correct.
That the reason given is not insufficient.
Correct.
What is there before this matter that I will have to depart from that view?
No, but I am prima facie on the documents. I'm trying to satisfy this honorable court that you see this is the documents I have annexed. So where I will go? On this count alone, every will be rejected, someone will be selected. All documents are there.
What is the relief you want?
I am still now, according to my information, the financial bid has not been open. Furthermore, no work order has yet been given. I am the qualifying person. 100 crores I have shown from the balance.
So your technical bid has been rejected.
Technical bid has been rejected.
Yes, you're for the railways. What do you have to say?
What my learned senior friend Malad submitting Malad, that was in respect of might be Malad, he has a very good case. So far the financial bid is concerned. But so far the technical bid is concerned, Malad, because there are certain documents which he has to be uploaded while applied for the tender. Malad, and for that, Malad, I have to take instruction. What are the instruction is that, but the 10 number was not there, Malad. While
What
applying,
number?
The 10.
What is 10?
The tax deduction accounts number, Malad. That was not there, Malad. But the application would be made.
Mr. Bandyopadhyay, at best, I will ask them to file a report.
Yes.
On the alleged grounds.
Yes.
But I will not stay the order.
No.
Or staying the tender does not arise. I've never done that. But stay the order.
May I make one prayer that there's
Yes.
one Lordships can seek for the report. But I am praying, I've understood your Lordships. But if any step has been taken in the meantime, at least that would be abided by the result of the report.
What steps have they taken? You're saying that they haven't done anything.
No, they may take steps since your Lordships is not passing any interim order. They will, in the meantime, they may take steps.
These orders make sense.
Oh, yes.
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 How? You discourage the other bidders.
No, I am not. I am not discouraging the other. They let them know the fate of the case. They have to also. If I am illegally rejected, then I have a case. Let them know the fate of the case also. Let them proceed. I don't mind. Let the port also take the risk. Sorry, rail is all takes the risk.
Malad, in the other case, Malad has observed, Malad.
The other case, there was another point. The rejection was not challenged. If I remember it correctly. There was no prayer for revoking or for cancelling, quashing the rejection.
That was there, but Malad has clarified, Malad, because the technical bid for which
I'm not giving him any interim relief. I'm not saying that you will have to consider the technical bid. That I will not do. I will not give that to Mr. Bandyopadhyay. That Mr. Bandyopadhyay's clients will participate in the rest of the tender.
38 of the tender, Malad, clause
You
38
answer
of
on
the
the tender terms, please. Yes.
Malad kindly comes to Malad page 54, Malad.
I can't hear you. Microphone, please.
Malad kindly comes to Malad page 54, Malad.
54.
Malad.
Yes.
Clause 38, Malad.
Yes.
When they applied for the tender, Malad, they should have the knowledge of this clause 38, Malad. Malad, the railway authority reserved their right for rejecting the techno-commercial bid, Malad. That is what, Malad, clause 38 says, Malad.
Yes, Mr.
Malad,
I think there was
Malad,
apart from clause 38,
Whatever,
there
Malad,
was another
whatever.
clause which says that the railways, if I remember,
reserves the right for rejection.
Malad. That is clause 38, Malad.
Very good.
15 or something.
Malad, it's all right. Malad, two things are there. One is existence of power. Another existence of power, rejection.
Yes.
And another is the exercise of power. Power of rejection with them. Whether that power has been exercised reasonably or not. In a court, blood under the Article 226 in a judicial review, court can go into that questions or not. But sometimes reason is not required to be given to me, but to set, Lord, when a question has been raised and Lord, the challenge has been made.
Mr. Bandyopadhyay, 2016 14 SCC 172.
My Lord, your Lord, reason Lordship has referred to, I have seen them. Lord,
That is that Soma case.
State of
HOMA.
Jharkhand, yes, this sounds a similar clause where the authority council reserve the right to reject any of the swans received without assigning. I am all right, but take the cases, my Lord, earlier cases before the 85-3 SCC Constitution when judgment that the one line termination of service.
Mr. Bandyopadhyay, law develops and is allowed to develop, at least in our country, through precedents.
Yes.
Now the Supreme Court's consistent view is that no interference in tender matters unless a tough decision has to be taken to show that it's arbitrary.
Yes, exactly. Now, Mullah, two things. One is reason is not required to be given. One thing. But when I am challenging the decision, whether the court is having the power, leave aside me. And Article 226 to go into the question.
Mr. Bandyopadhyay, if you're happy with the report,
Report and they abide by the result of the applications.
How will that help you?
Well, that will help me. If I succeed,
because the tender will not progress anyway.
No, progress. Why not progress? Let them progress everywhere. Let other comes. I don't mind. But if I am rejected ultimately. But if this petition is allowed.
The petitioners are aggrieved by the rejection of their THEIR, their techno-commercial bid against a tender, capital T, floated by the Southeastern Railway. Stop. The impugned rejection is dated 24/4/2023. And the reason given is the disqualification under in packet A. Stop. Next, the petitioners, through learned counsel, say that the rejection is arbitrary since the petitioners fulfilled all the eligible criteria under the essential conditions of the tender document. Stop. Next. Aki paragraph karo. Council submits that packet A relates to packet A referred to in clause 12 of the instructions to the tenderer, capitals, requires the bidders to be evaluated on the criteria mentioned in paragraph 12. Stop. The essential/mandatory criteria are stipulated in paragraph 17, para 17. Stop. Council places documents to show that the petitioner number 1 has fulfilled the essential eligibility criteria under clause para 17.2, both in terms of experience and net worth. Stop. Documents corroborating the same are shown to the court. Stop. Mr. Bandyopadhyay, what is the clause at page 46? The stitching, I can't see it. Page 46. Minimum eligibility criteria. What clause is that?
46. 7. Oh, yes. 46 is 17.1. 17.1 minimum eligibility criteria.
That is 17.1.
17.1.
I can't see it.
And teaching is there. And your lordship was
no, that is
17.2.
Yes. Keep bola last step. Experience as well as net worth. Stop. Next, although this court had decided a similar issue in 5-Star Logistics versus Union of India, WPA 10716 of 2023 on 11/5/2023, the documents shown in the present case require the tendering authority / Southeastern Railway to file a report indicating the basis on which the petitioners have been rejected, indicating the basis on which the petitioners ' techno-commercial bid has been rejected. Stop. In the other matter, the petitioner before the court had not challenged the letter of rejection, and the petitioner had instead asked for stalling of the entire tender process. Stop. Next. The report should be filed by capital R.
After the vacation, my lord.
Naturally, when?
1 week after vacation, my lord.
By 9th June 2023. Reply within?
Sir, হবে না। আমাকে instruction এসব
3 দিন 3 days.
Weekend টা পেয়ে।
3 days.
Reply within 15th June 2023. List this matter on 16th June 2023. Stop. Next, any steps taken by the respondent authorities in the meantime shall abide by the result of the writ petition.
I'm sorry, in the morning I was addressing. I could not come in the morning. I'm sorry.
That is all right. Yes. Call on the next matter, please.
Item number 34.
Lord, I appear on behalf of the petitioner, item number 34, my lord. My lord, petitioner before your lordship, my lord, is involved in the business of selling liquors, my lord, in the district of Birbhum, my lord. He had got the license, my lord, in the year 2019, and since he has been carrying on business. Now, what had happened in the year 2023, sometime in January this year, my lord, some of the villagers, my lord, they lodged a complaint and they are creating disturbance so far as running of my business is concerned. And that, my lord, compelled me, my lord, to make an application for transfer of my business to some other place. I've indicated that.
Yes.
Now, my lord, today in the morning, yesterday, my lord, I have received a communication, my lord, from the district magistrate.
So you applied to who?
My lord, I applied, my representation is at page 42 to the collector, to the excise officer, my lord, I have made this representation, my lord, to the additional district magistrate, to the excise officer, page 42, page 44, and my lord, page 46 to the superintendent of excise. Now, my lord, after I filed the writ petition, my lord, a communication was made to me yesterday that your application for transfer, which I compelled to do it under the prevailing circumstances that villagers don't want me to carry the business, that was rejected. Absolutely no reason, nothing, my lord. What I respectfully submit before your lordship.
So that is not part of the writ petition?
No, because this was informed to me day before yesterday. The order was passed, my lord, much before. Kindly have a look at this, my lord. It was passed on 10th of March, but communication was made to me. I was informed, my lord, day before yesterday by a registered post, which I received. So, my lord, I could not challenge. What I respectfully pray before your lordship today, that kindly, my lord, permit me to amend the writ petition because the rejection has to be challenged. My prayer in the writ petition, my lord, was...
Why don't you withdraw the writ petition and leave to file afresh?
My lord,
That is a much safer way, Mr. Deb. Because again, the amendment will be challenged and this is happening in a number of other writ petitions.
very well, my lord.
Complete waste of time.
Absolutely. I would do that. Now, my lord, one thing, my lord, I need, my lord, some sort of a protection, my lord, because kindly come to, my lord, page 33. Because since they have rejected my prayer, my lord, at least
33.
page 33, the complaint. It's a mass complaint made by the villagers. And I'm having great trouble in running the business. Kindly have a look at this objection, my lord.
No, you are running the shop since when?
My lord, since 2019. License was in the name of somebody else, then it was transferred in my favor. That I have annexed, my lord, at page 13. And there was no complaint till such time. And kindly see the reason of the complaint, that there was a temple. My lord, I do not know, bad impact on youths, because I run the business in the congested area. And today, my lord, the situation is, I can't open the shop, my lord, every day. They come in front of my shop and they create disturbance. What I respectfully pray, my lord, I'm entitled to run the business because otherwise there is no such reason. I got the license, 4 years I've been doing it. Kindly, my lord, permit me, my lord, in case any disturbance is created, to approach the local police authorities. So can, my lord, they give me adequate protection so that I can run the business. And so far as rejection is concerned, lordship can record this, that keep this document on record and permit me, my lord, to challenge it. This protection, my lord, I want.
As far as first prayer is concerned, that is not neither here nor there, since that is not the subject matter of the writ petitions, nor in the prayer also, my lord. And that liberty, he may not require any liberty, as and when any businessman or any person who is facing any trouble, untoward incident, there is possibility of breach of peace, he can always approach the police authorities. No liberty from any court of law is at all required, so far as first prayer is concerned. And the second prayer, my lord, it is true, my lord, we have posted by post, lordship. Order was passed on 10th of March. So right now he has received the order, he has to challenge this order. That is not challenging this present writ petition. His only prayer is to consider it.
He can't if the order reached him after filing of the writ petition.
But that is beyond our control, since we have sent the order through post.
Beyond control, order passed on 10th March and I get the communication the day before yesterday, beyond your control. My lord, I have made an interim prayer. My learned friend said there was no interim prayer. That
so
is,
you want to shift to where?
My lord, shift to, my lord, kindly have a look at, my lord, page, my lord, 46. I have indicated the place and that is my prayer at the bottom.
From Shaithia to Bolpur.
In the same district at the bottom, page 46.
Yes.
Prayer is made, my lord, regarding my... Kindly have a... Yes, kindly come to page 11, the interim prayer which I sought, my lord.
Yes.
Injunction be passed directing the respondent authorities not to create any disturbance with regard to the smooth functioning of the business of the petition. That prayer was there.
Now,
and by your...
Mr. Shah, 1 minute, I will come to you. Yes.
And my lord, by of an abandoned caution, my lord, I made the local police authority as a party because I was apprehending this will happen. So give me this protection. I am entitled to get this protection, my lord, under the constitution to run the business.
No, he has to say, my lord, which respondent authorities is creating problem. He is saying some mass petition is there from the villages, the local people. They are not the respondent here. He is praying injunction against the respondents.
How is he prejudiced? I do not know.
How can he make this prayer that this is very much within these petitions, within the prayer? The prayer is something different. He is seeking injunction against some authorities.
Respondent number 5.
This is creating any hindrance.
Respondent number 5 to give me this much of protection. That
yes, it's not the prayer, Lord.
The petitioner carries on the business of selling liquor from a shop, presently carries on business of selling liquor from a shop situated in Birbhum. Stop. The petitioner applied for transfer of the shop from Birbhum to from a place in Birbhum to a second place in the same district by reason of complaints made by the local people.
Yes, page 33.
And communicated to the excise commissioner on 30/1/2023.
Copy was also given to me, my lord.
30/1/2023. Stop. The petitioner also received a copy of the said complaint. Stop. Next, learned counsel appearing for the petitioner submits that after filing of the writ petition, the petitioner received an order dated 10/3/2023 from the Collector of Excise, Birbhum, rejecting the petitioner's proposal for shifting of the shop. What is CS shop?
Country liquor.
Country Street.
Spirit.
Subsequently, my lord, I was permitted to run
shop-
the foreign
shop.
liquor also.
Stop. Counsel submits that the petitioner should be given liberty to withdraw the writ petition and file afresh. Stop. Next. The writ petition was filed on
My lord, it was filed, my lord, on
the order rejecting the petitioner's application dated 10/3/2023 was received by the petitioner only on 15/5/2023, which is more than 2 months, which is more than a gap of 2 months.
This is his submission. Like, no such documents or evidence have been.
Stop. Now, 15/5/2023. Stop. The writ petition was filed on
my lord, on 11th of 10th May.
10/5/2023. Hence, the petitioner could not challenge the rejection. Stop. The petitioner is hence given leave to withdraw the writ petition and file afresh. Stop. The writ petition already has a prayer for an order of injunction directing the respondent authorities not to create any disturbance with regard to the smooth functioning of the petitioner's business. Stop. The concerned respondents / complainants have not been made party respondents to the writ petition, and hence this prayer is directed only against those who have caused disturbance to the running of the petitioner's business. Stop. The petitioner can always approach the local police station for protection in the event the disturbance continues or takes on unmanageable proportions. Stop. Next. WPA 11713 of 2023 is disposed of as not pressed and with liberty to file afresh.
But only, my lord, only one sentence, lordship, my lord, adds the local police authority will consider, my lord. That's, my lord, only one thing if lordship adds. That happens.
The prayer and that
Because
is
that
the
happens.
police officer.
It
Until
happens, my lord.
something happens, well, some inaction.
Otherwise, lordship knows it.
Yes, the petitioner, as stated above, the petitioner shall be at liberty of seeking police assistance if so required. Stop.
Grateful, my lord. My lord, may I file the affidavit of service, my lord?
The affidavit of service is kept on record. Disposed of it, disposed of.
Item number 35.
Lord, my application. Lord, the prayer in the writ petition is for refund of the security deposit. The prayer in the writ petition is for refund of the security deposit, which was supposed to be done after the completion of the work. Lord, I have performed the tender was floated, work order was awarded to me. I had completed the work. The clause in the contract was that after completion of the
What is the work? Who is the authority?
the authority is the state. I'll tell you, Lordship, who is the specific authority. Chief engineer, PWD.
Yes.
Work was done, completion certificate also given. Thereafter, I had prayed for refund of the security deposit, which I had earlier deposited. They say that there were certain defects in the work and that it had to be rectified. I do that. Even after the...
I asked you, what is the work?
The work in the contract, I'm sorry. The contract was for work of construction of 4 numbers of single-story brooder shed at DCF Baramahula in the district of Birbhum. Construction of 4 numbers
So
of
you are,
single-story brooder shed.
are enjoying an interim order?
No, no, Malad, no, there's no interim order.
Oh, there was a direction to file affidavits, Malad.
Yes.
May I file the opposition, Malad?
So you filed the reply?
Yes, Malad, reply, Malad, may I file? I have served, Malad.
Mr. Dashgupta, you please come back after in June. This is after affidavits. I'm not taking up any hearing matters now.
That's this very short point involved. If in
What is
the,
the short point
the
involved?
opposition, in the affidavit in opposition, the only stance taken by the government is that they had some claim against me in respect of some other work, and that they can appropriate that claim as against me in respect of this claim.
What does the contract say?
The contract says that contract has that clause, but whether the document in support of which they say that they have a claim, they say that there is a earlier suit filed by me in respect of some other work where they have filed the written statement and a counterclaim. But we'll kindly see the counterclaim, whether it was filed or not. I have, in the reply, I have annexed the written statement which has been filed by the state. There is no counterclaim whatsoever. The suit is at the final hearing in respect of the other work. They say they have a claim, but they have not lodged a counterclaim with the written statement. The suit is in the final hearing. How can they say that there is a counterclaim and that is the reason why they cannot refund this money to me? There is nothing.
Mr. Bandyopadhyay?
Yes, Malad, irrespective of the fact, Malad, I have found from the reply that they have taken the stand that there is no counter claim, whereas Malad, our records, government records, had a counter claim in it, which we have annexed, Malad. Whether it's there or not, Malad, if required, Malad, I'll take those instructions. Now, Malad, the point is that, as my learned friend admittedly says, Malad, both the contracts from which they make this claim of release of security deposit, Malad, has a clause which says that we are entitled to retain the security deposit, Malad, if we have any claim. That word is there. So, Malad, it need not be an adjudicated debt. Malad, even if we have a claim, Malad, we can withhold the security deposit which is returnable to him. Malad, I'll rely on those clauses, Malad, irrespective of the counter claim. Malad, we say that we have a claim of 84 lakhs against the petitioner. So, Malad, this part has to be, in any event, has to be gone into, with the additional point that I'll take, Malad, a simplicity money claim cannot be brought to this court, Malad, because there's nothing admitted. If it was the case that it's an admitted amount, I should return it, that's a different thing. But I say that I have a claim against them of 84 lakhs. Well, that part has to be gone into, whether a simplicity money claim can be pursued in a 226 application.
Mr. Just 1 minute, please. Circuit bench matter gulo kokhon ache? Eke dakho, Sudipto ke dakho. Yes, Mr. Dashgupta, you come back in the first week, second week after reopening. Because I will not take up this. Today we are rising early.
I understand. What
Yes.
Very
give me a date when you will come back, and I will
Table.
record that. I will, whichever date you choose.
Your choice.
Well, it's 7th. It's reopening on 5th. May I come back on 6th?
Whichever date.
6th.
Yes, that is fine. Yes, affidavits are complete in the matter. Stop. The issue is with regard to refund of the security deposit, which the petitioner claims under the terms of a contract between the petitioner and the state authorities. Stop. According to learned counsel appearing for the respondents, the respondents also have a claim of rupees 84 lakhs from the petitioner. Stop. The allegations need to be gone into. Stop. List this matter on 6 June 2023 as prayed for.
Grateful, Malad. Grateful.
Lordship, I appear for the petitioner. My client is runs a proprietorship business for in the field of iron and scrap materials. Lordship, this is my writ is seeking reversal of an inadvertent transaction made by my client in favor of one of his suppliers.
What's an inadvertent transaction?
Lordship, the thing is, my client, for the purpose of his business, he regularly uses his internet banking portal. Now, there are a list of beneficiaries that are pre-added. On 28th September, he intended to make a transaction of rupees 16 lakh to one Geeta Creations. However, he ultimately ended up selecting one Ganpati Traders from his list of pre-added
So
beneficiaries.
you gave 16 lakhs
My lord,
to Ganpati Traders.
my lord.
How is it a writ under 226?
My lord, the thing is, I had written to my bank, the recipient bank, as for the reversal of this transaction. Now, the recipient bank, he says that I need a debit consent letter, that since there was no mismatch in the account number and the account name, hence there's no deficiency of service on the part of the bank. So I would need a debit consent letter from the beneficiary, from the holder of the account. Now, when I approach him, he says that prior to
Who is him?
the recipient, that is the respondent number 4, the private respondent, the recipient of the money in whose account the money is being credited. Lordship, he says that prior 4 to 5 months prior to this transaction, he had already written to the bank that he's no more running the business, his account be closed. So I take the matter back with his bank, that is Karur Vysya Bank. He tells this transaction was made on 28th September. I immediately write to both the banks on 30th. Firstly, the bank replies that I would need a debit consent letter. Post that by the end of October, that is 30th October, 28th October, Lordship, the bank again comes up and tells me that this bank account is under debit freeze as per the order of the GST authorities.
What is the interim order you want?
Lordship, interim order, I would pray for that until unless the writ petition is disposed of, the GST authority does not settle any alleged disputes against any dues of the respondent number 4 from his bank account, since the account is under debit freeze pursuant to the order of the GST authorities. Pending this writ petition, the same may not be adjusted against any of his dues.
I don't understand. Yes. What do you have to do with the bank?
I'm appearing on behalf of the ICICI Bank. I'm not the answering respondent, Your Worship. And even I am seeking for a copy of the writ petition. We haven't received from the petitioner.
Lordship, we had served, but the track report says addressee moved. So we have an extra copy.
I'm giving you leave to move the vacation bench. Yes.
Lordship, if I may press for my interim order, that
No. How can you press for your interim order without serving a copy of the writ petition?
Lordship, it was served, but it says addressee moved, and they are not even the answering respondents, Lordship.
Then without, I will not pass any ex parte orders. Have you served all the respondents?
Yes, my lord. Yes, my lord.
No, you can move the vacation bench.
Lordship, the answering respondents have been served. They have.
Who is the answering respondent?
Lordship, respondent number 2, Karur Vysya Bank, the banker of the recipient.
Karur Vysya Bank is amenable to 226.
Yes, my lord. As per your lordship's order, yes. In
As
another
per
matter.
my order, what my order?
Lordship, in another matter. Lordship.
Against Karur Vysya Bank?
Yes, my lord.
Okay.
Lordship, in this particular matter also, maintainability issue was taken in paragraph 3. Your lordship has was of the view that private banks are amenable
This
to
is
treaty.
for the ECLGS scheme, not against anything done by the bank.
And also,
This is
lordship,
the government, ECLGS scheme floated by the state government.
and lordship, I am also seeking directions against respondent number 3, that is the GST authority, that they should be
First,
injuncted
the maintainability issue has to be gone into. Absolutely not. Yes.
Then I
What
may
I'm
come back.
saying, this judgment of mine is against the state governments. Karur Vyasa was just a party, not the answering respondent.
And lordship, respondent number 3 has been served. That's GST
No,
authority,
no.
which is
The answering respondents are not here. Stop. Who is for the respondent number 3?
lordship, they are not. I presume they are not. They have
The
been served.
answering respondent being the Directorate General of Goods and Service Tax Intelligence is not here. Stop. Learned counsel appearing for the petitioner claims that all the respondents have been served. Stop. Next, Aki. Learned counsel appearing for the ICICI Bank / respondent number 1 claims that counsel has not received a copy of the writ petition. Stop. Next, since learned counsel representing the petitioner submits that there is urgency in the matter, the petitioner is given leave to move the vacation bench. Next,
Affidavit of service has been filed.
the affidavit of service is on record, is kept on record. Next.
Item number 37.
My lord, item number 37, my lord, I appear on behalf of the petitioner. On the last day, my lord, we filed our written notes and arguments, my lord. This is matter, my lord, this
Yes, I remember. Yes.
all parties have filed, my lord, on that was done on 8th of May.
তো এসিটাকে একটু বাড়িয়ে দাও তো। নোটস গুলো দাও।
একটা আমারও নোট আছে, হ্যাঁ?
Only on the point of maintainability.
No, my lord, maintainability and allowing the two CAN applications. One is for, my lord, filing of a report, and the other one, my lord, if lordship directs me to go there physically, lordship was initially of the view, though my learned friend didn't indicate the time, then I would go there physically. But my lord, the entire interrogation, whatever will be done, my lord, if I go there physically, that should be videographed. These are the two CAN applications lordship has had.
No, so the notes are filed also on the CAN application.
CAN and maintainability on this.
My lord
Not
had-
on merit, because
lord-
I have a point to argue on merit without prejudice to the merit.
Yes.
My lord had heard on maintainability. My lord had heard on maintainability only, my lord. Question of CAN application and applicability of those prayers come only after the maintainability part, my lord.
The notes, capital N, filed on behalf of the petitioners and the SFIO.
SFIO. my lord.
SFIO.
Okay.
Are before the court. Stop. The notes are essentially on the maintainability of the writ petition. Stop. The petitioners have also filed two applications. One for filing of a report by the SFIO, and the other for videographing the proceedings.
Proceedings, if lordship directs me to go there physically, because I said I will be.
For videographing the proceedings, if the petitioners are, who is both of them or just
No,
one?
my lord,
Just one.
petitioner number 2.
Number 2.
If the petitioner number 2 is directed to physically appear in the proceedings before the SFIO, stop. Next, reserve for judgment.
I'm grateful, my lord.
One minute. Petitioner responded notes গুলো আলাদা করে দাও। Yes, call on the next matter, please.
Item number 38.
And I appear for the petitioner. Madam. This is the matter lordship was pleased to hear day before yesterday with regard to that Falta export processing zone. Now, between the pendency of the writ petition, the export authorities, the processing zone handed up us with a memorandum by which they admitted that 12 lakhs rupees will be paid to us and that we will not withdraw all our claims, other claims. So, but this money was not paid to us and it was for last 1 year, nothing was done. So my lord's pleasure was on the last day, but took instructions with regard to a memorandum that was given to us. So we now, with regard to the instructions, there must be a
But in 2014, in the writ petition number 33831.
Microphone, please.
in 2014, my lord, in the writ petition number 33831, there was a direction to withdraw civil suit, money suit number 77 of 2014. May I hand over, my lord, a copy of the order? Secondly.
This is annexed to the writ petition. We have
Yes,
withdrawn
now,
it.
my lord, pursuant to this direction, my lord, in 2000, the last page of this writ petition, in 2021, they resolved a resolution by the Board of Directors to withdraw. That is the last page, 180 of the writ petition. Now, my lord, after this resolution, we have not received whether the suits or any other pending applications were withdrawn or not. First. Secondly, my lord, we have given a rent. Now, we are supposed to receive the rent, whatever rent. If they want to exit from the processing zone, then they have to give us an application surrendering the land. Then we can adjust and send it back. Third issue, my lord, if this, according to this memorandum that is dated 23rd of February 2020, this has not been signed. Nobody has appeared from their office with regard to the withdrawal of the suit and all these applications as per the order.
Mr. Mitra, have you not communicated to them that the suit was withdrawn?
Yes, yes, this is recorded in the order. Even this memorandum records this. That all claims will be taken care. We will not press.
My lord, it will be withdrawn. It will be withdrawn, not withdrawn yet. It will be withdrawn. After discharging the money, it will be withdrawn.
Where is memorandum?
The memorandum this memorandum further records Antarctica also agrees that on receipt of 12 lakhs,
the last line.
interest, they will relinquish all other monetary claims.
They will withdraw. Says will withdraw. Have you withdrawn after that?
No, I'm on item number 2. We will relinquish all my monetary claim and will withdraw the pending litigations. So if this is honored, we will also honor our part, definitely on instructions. Because if they pay us 12 lakhs, everything is squared off. And
you pay the 12 lakhs, they will withdraw?
My lord, that has been given. The instruction was of 2014, my lord. That has not been obeyed yet. And they are in still possession. They are asking for further renewal of. Kindly see the paragraph prayer. They are asking for further.
Very well. You give me a date by which you will pay. I will also direct them by a date to withdraw.
Let them withdraw. Give us a letter. We will pay the money along with the interest.
Very well. I am keeping the matter on. Give me a date in June. You withdraw with evidence to them, and I will direct them to pay.
Yes,
10th June? 15th June, because the summer 15th June. No.
Very well. The memorandum.
We will honor our obligation in terms of this memorandum.
The memorandum dated 23/2/2022.
We have made a supplementary affidavit for this also to bring it on record.
With reference to the outstanding rental dues.
No, this is a
from.
This is a guarantee. This was a demand draft given as per the instruction of the court, my lord.
This is the refund that SEZ.
1 minute. What is this? What is it? What have you handed up then?
This is the memorandum records that a sum of these 12 lakhs will be refunded by the SEZ to us.
I'm just reading out the subject matter. Then you have handed up something else to me.
No, sorry, madam. Yes.
Ki bolam? Mentioning the subject matter as the outstanding rental dues from the petitioner to the SEZ Falta. Is that correct? To the SEZ Falta has 3 clauses. Stop. The first clause says that SEZ Falta will refund rupees 12 lakhs along with interest in compliance of the order dated 3/9/2015 passed by a learned judge of this court. Stop. The second clause says that the petitioner agrees on the receipt of rupees 12 lakhs to relinquish all other monetary claims. Stop. The third clause says that the petitioner also agrees to withdraw the above matter, i.e. WP 33831 of 2014 and all other pending litigations. Stop. Connected to the writ petition. Stop.
My lord's pleasure to one line where we record that in the first opening paragraph it records the rental dues are found to be cleared. which is payable from my side. That is
Next.
that-
The first clause, the first part of the memorandum mentions that the outstanding rental dues were found to be cleared up to 31/3/2021. Stop. Next. The three clauses make it clear, comma, with beyond doubt, comma, that the petitioner will relinquish all monetary claims and also withdraw the pending writ petition being WP 33831 W of 2014 after receiving rupees 12 lakhs along with interest from Falta SEZ. Stop. Admittedly, comma, this amount has not been paid to the petitioner till date. Stop. Falta SEZ is hence directed to pay the amount of rupees 12 lakhs along with the applicable rate of interest, which shall be 6% from the date of the memorandum to the date of payment.
Well, this payment was made in 2015.
My lord, this is a 2022 understanding, my lord. Rent is still due for 3 years.
31st May 2023. Stop. This is in terms of clause II of the memorandum. Stop. The petitioners shall thereafter give effect to clause III, which is to withdraw the writ petition and all other connected and all other pending litigations connected to the said writ petition by, give me a date, please.
The writ petition was disposed of.
My lord, another
This
writ petition of 2016 is still pending. WPA 1
by 15th June.
By
once you
15th June 2023. Stop. The petitioner shall give evidence of the withdrawals of all pending litigations as mentioned in III of the memorandum to the Falta SEZ before the returnable date, which is 20th June 2023, when the matter shall be next listed.
My lord, this understanding was of 23rd February 2022, my lord. Thereafter, 3 years rent, 21, 22, 23 is pending, my lord.
First, you pay the 12 lakhs, we shall see. Yes, next.
Deeply obliged.
Memorandum, I have filed a supplementary affidavit to bring it officially.
Yes, the memorandum is also already part of a supplementary affidavit filed before the court. Stop.
Deeply obliged. Deeply obliged.
Lordship, I beg to appear as the petitioner. On earlier occasion.
Without the matter being called on?
Sorry, Lordship.
Jalpaiguri matter. Jalpaiguri contempt item number 1.
Lordship, I'm appearing for the respondent bank.
And I am appearing on behalf of the auction purchaser, Lordship.
Yes.
Lordship, I am appearing in the for the petitioner. Lordship, in this matter, on last 29th of March, your Lordship has been pleased to pass an order by directing the bank authority with liberty to me to submit a payment of rupees 30 lakhs with a proposal for consideration of installment payment regarding bank dues.
Where is the order?
Lordship.
This is coming up for the first time?
First time. Page 50 to 53. Page 50, Lordship. 50,
Yes.
51 is the order.
Yes.
Now, on the basis of said order, lastly, I had been to the bank on 5th of April 2023.
1 minute, please. Mr. What is the, I will have to direct service, or are they already here?
No, there is a application for application I have served, stay application, because in the meantime,
Stay of what?
stay application regarding the construction on the land. The private respondent criminally trespasses the land without any order from the district magistrate in connivance with the bank.
No, this is a contempt. So
This is contempt. I have not served the contempt application to anyone.
yes, so very well. So what is the application you're talking about? Very well. The contempt arises out of an order passed by this court in circuit on 29/3/2023. Top. The contempt petition should be served on the alleged contemnors. Stop. When do you want to come back, Mr. Dhar?
Lordship, on 6th.
List this matter on 9th June 2023.
Lordship. Now the application.
Yes, what is the application for? Have you
Application-
served the copy of the application?
All the respondent I have served.
Yes, what is this application for?
Application for stay of construction, which is doing by the private respondent. Lordship,
Application filed in the writ petition.
application filed in the writ petition. And
And
copy of
writ petition has been heard out by the court.
Lordship has been heard out. This writ petition where the order dated 29th is arise.
So the order of 29th was passed in this writ petition.
In this writ petition.
Mr. Dhor, can I hear the writ petition now? I can hear only the contempt. The writ petition has to be heard by the circuit bench.
Lordship, have passed an order, and I have mentioned the writ petition before the Honorable Circuit Bench, but it is not, unfortunately, it is not listed. And in the meantime, on 26th, the private respondent, I have filed an application for addition of party, which is being can number 1, to edit the private respondent along with the chief manager, which by mistake he was not added in the main writ petition.
No, what is the relief you want in the application?
In the application, Lordship, let the private respondent be restrained to do any construction on the land which they trespasses on 26th of April 2020. Only this. And let them file affidavit, and after that the matter may be decided.
Why should I give an interim relief without understanding the matter? Who is the private respondent?
Yeah, Lord, I'm appealing for the private respondent's lordship.
Yes.
Lordship, the thing is that I have purchased the land on the basis of a statutory sale by the respondent banks. Since the petitioner have failed to.
You're the auction purchaser.
I'm the auction purchaser. The land has been registered in my favor. At present, I am the lawful owner of the land, lordship. They have.
Mr. Dhar, you will have to wait for the court to ask you questions, and then you
Lordship,
make it.
Lordship.
Are you the auction purchaser?
Lordship, yes, I am the auction purchaser.
And who is the petitioner before the court?
Mr. Devobrata Dhar is the petitioner. His client is the petitioner.
The borrower?
He is the developer. He is the developer.
Developer. And what are you doing? So the developer is against the auction purchaser.
Lordship.
Very well. Mr. Dhar, why should I give you any interim relief?
Lordship, because in the matter, Lordship, I have challenged the auction later because initially there was a amicable settlement between the bank and the borrower, Lordship. And on the basis of that,
Who is the borrower?
Borrower is appearing for Mr. Kunalji Bhattacharya. I have told him and I served him notice. He told me that he will appear. But
Mr. Dhar, just make your case, please. Hurry up.
I have challenged the auction notice in the writ petition, Lordship, because there was an amicable settlement. On the basis of said settlement, there was no objection for doing construction by the developer. And I have, at the time of said settlement, I have paid an upfront money of 12 lakhs to the bank and said no objection still exists. It is not cancelled by the bank, not revoke it at any point of time or disputed it. Now, during pendency of this, the auction notice is issued by the bank, and challenging that auction notice, I have come before this honorable.
So you are the developer, so you will also make you are also making construction.
Construction, I have done the preliminary work, soil test and everything, Lordship, the preliminary building plan, all these
But
things.
how can I restrain the auction purchaser?
Because Lordship, Chair, because there is an amicable settlement of, there is a settlement.
Mr. Thought, no,
Lordship.
unless I hear a
Lordship, the bank may kindly be allowed to put the real picture of the case, my lord. Matter
I'm
is.
not giving any interim order. No, you come back in June. Yes.
And Lordship, may I humbly pray one thing? Any construction, if in the meantime they are done, that will be abide by the result of the deed. Only these things, Lordship.
My lord, surface proceedings are going on. And under the surface proceeding, my lord.
Surface
proceeding against the borrower. Against the borrower, surface proceeding has been initiated by the bank, and under the surface proceeding, the auction sale has been conducted, and sale certificate has already been issued. Sale deed has already been executed on 17th of March 2023, my lord. The borrower
purchaser is before the court, please. Yes. All that is beyond, before this auction purchaser came to the court. Is that correct?
Before. Yes, my lord. Yes, my lord.
Yes.
My lord, the OTS was offered to the borrower, and which was not honored by the borrower, and the OTS was duly cancelled, and it was duly informed to the borrower on 7th of April 2020 only. Thereafter, the surface proceedings were initiated.
The writ petitioner / applicant before the court claims to be the developer in respect of a plot of land which was subsequently auctioned by the respondent bank and purchased by the which respondent?
Respondent number 11, Lordship.
Respondent number, private respondent number 11. Stop. The borrower is also a party. Respondent number?
5, Lordship.
/ respondent number 5. And so is the bank. Stop. The applicant prays for an interim order restraining the respondent number 11 from making any construction on the plot of land, on the concerned plot of land. Stop. This court is not inclined to do so before hearing the parties, particularly when the respondent number 11 paid good money to purchase the plot of land in an auction conducted by the bank in pursuance of proceedings under the SARFACI Act 2002. Stop. Next. Affidavit in opposition to the application by 9 June 2023. Reply by?
1 week, Lordship, there.
By 16 June 2023. You can take more time. By 20th June 2023. List this matter on 23rd June 2023. Stop. Any steps taken by the parties in the meantime shall be subject to further hearing of the matter.
Lordship, deeply obliged.
Yes. Any other circuit bench matters? সেটা অন্য ম্যাটার সেটা অন্য ম্যাটার ইয়েস তাহলে 16 করে দাও 23rd করে দাও নেক্সট any appellate side matters which are due to be heard? You wait till tomorrow. Yes.
Assigned matter, my lord, item 296.
Assigned matter, there's no time today. I will take it up on some other day. Yes, call on the original side, please.
Original side.
My lord, I was addressing your lordship for your lordship's convenience. What I have done, my lord, there are about
10 notifications under different rules. He has made it and,
Pertaining to what?
my lord, pertaining to various stages of the election, and he has challenged none of the notifications. When I say, my lord, it's important that your lordship sees what these notifications are about. So, my lord, what I have done, the relevant ones, I have mentioned with the corresponding rule,
Yes.
my lord. So, my lord, may I hand over, my lord, a list of these notifications? And if you see the notifications, the answer will come after that, my lord. If you see the list of the, because I
Have
can't
you
draw your.
served a copy on Mr. Shah?
No, I'm just handing over a copy. It's just, I prepared, my lord, the list of these notifications. My lord, the first of the notifications which he has annexed, and I've given each page number. My lord, it is not a gazette notification, the first one. It is, my lord, under a particular election rules for what he is called the Ahmedabad chapter. It's under the bylaws. So, my lord, it's wholly irrelevant for the purpose of this happening. Totally irrelevant. Now, the rest, my lord, are gazette notifications, because this is an act of the parliament. My lord, I've given the page numbers.
What is an act of the parliament?
My lord, the statute, the Courts Accountant Act, if you see the preamble to the act, it is framed, my lord, under the, it's a parliament, my lord, has framed this. It's a central statute. My lord, the reason I'm telling your lordship regarding the maintainability, because it's a question, my lord, there are number of gazette notifications. My lord, I told this yesterday, my lord, under Article 13 of the Constitution of India, all these notifications under Article 13(2) small a, my lord, all notifications are, my lord, law. My lord, as your lordship knows, my lord, the state or the legislature frames laws under, my lord, Article 245 of the Constitution of India, and it says subject to any other law in the any provision in the Constitution. And, my lord, the provision in the Constitution is Article 13(2) small a, my lord, which says that any law, all laws are valid unless it infringes the fundamental right, my lord, of the petitioner. Your lordship, I have got a copy of the Constitution. Your lordship,
I have.
yes. Now, my lord, this is 13(2) small a. That notification is also law, my lord, unless it infringes the fundamental right. Now, my lord, my humble submission first, and that's why I draw your lordship to this notification, is that he has, in this writ petition, he has not challenged a single notification. My lord, his challenge is not to a single notification. What he is challenging is a letter issued by the returning officer pursuant to the notification saying that your name has been excluded. Now, my humble submission, without challenging these notifications, which are law, my lord, and I have to follow it, my lord, there is this writ petition is not maintainable. Also, he has not, his entire challenge is on, my lord, the notice given, my lord, to these notifications. Now, my lord, what the notifications and why, my lord, this is important. That's why I made a list of these notifications under the various rules. And I mentioned against each column the rule, relevant rule.
All these notifications relate to the elections.
Yes. That's why, my lord, I am saying all relate to the.
So what is the point? The point is that there is a finality to the scrutiny.
Yes. There's a finality to the scrutiny, and, my lord, unless he challenges the rules or the notifications itself, my lord, he's not entitled to any relief for stay of that particular notice which he is asking for. I will give the other point to be, my lord, even if your lordship thinks about a discretion or whether they say that why don't you pay and regularize it, that can't be done. Because, my lord, if you see Rule 7, it says whatever, if he was not a defaulter as on 1st October 2022.
No, there's a difference between 5 and 7.
Yes, my lord, no, both 5 and 7 say if he was not a defaulter in 1st October 2022. Admittedly, he was a defaulter, my lord, in 1st October 2022. So if your lordship is asking, yes, you pay, or you pay, and again reverse the process, my lord, that is not possible. My lord, that is now, my lord, regarding the element of the discretion, let me answer your lordship by showing you My lord, I'll just take, my lord, 5 minutes and finish, my lord, because the urgency is also there, my lord, so far he is concerned. If you lordship, my lord, kindly sees the first of these notifications, and that's the only one which I will show your lordship. My lord, just have a look at page 65 once, my lord. The rest, my lord, your lordship can check, my lord. I made a.
Why should I check if they are not relevant?
No, rest are relevant, my lord. They are relevant because my lord, for the argument which I am making. Now, my lord, your lordship will find, my lord, in page 65.
Yes.
Elections were announced on 31st March 2023. My lord, your lordship will find from the last line, conduct of elections to the council and regional councils. So, my lord, there are two elections happening. My lord, one is the council and the regional council. So, my lord, separate election is for, my lord, the western, southern.
You're saying that the petitioner is already an office bearer.
He is for the regional council, my lord, which is outgoing. He is already going, my lord. In the 2003, he is already in the council as part of the western circle. He is there, my lord. But this, my lord, please, my lord, there are two types of election being held. One is for the central, which comprises of, my lord, the 4 zones, and separately also for the regional. Now, he's an outgoing member of the council from the western zone. My lord, kindly see, my lord, my lord, I will give you the relevant.
Both this is not relevant. You come to 65, please.
No, my lord, 65. Kindly see, my lord, the date of issue of notification is 31st. Then, my lord, kindly see the last date and time of receipt of nominations is 21st April. My lord, so he filed his nomination. Then, my lord, the last date for scrutiny of nomination, my lord, all rules are mentioned, is 29th and 30th. So, my lord, on 30th, I issued a gazette notification after scrutiny, my lord, of this. And then, my lord, last date of withdrawal is 10th May. And then, my lord, kindly come next page.
Withdrawal of nominations.
Nominations, my lord, because I have to print ballot papers. Then, my lord, my lord, E is important. Last date and time of receipt of permission to vote by post. Someone wants to vote by post, that he must submit by 1st May. And then, my lord, last date of receipt. So, my lord, the postal ballot. So, if you, my lord, after I give the postal ballot, these people have to submit. And, my lord, the last date is given as 1st July 2023.
No, what is this? Receipt by post of
yes,
ballot
the
papers.
people who are applying for postal
the,
ballot.
The ballot papers must reach and be received by 1st July.
1st July, correct, my lord. And my lord, and then commencement of voting is there, and declaration result 12th July. My lord, the elections are going to be held, my lord, in Delhi. Now, my lord, kindly see 5. And this nomination scrutiny for scrutinizers are obtained. My lord, the first is, my lord, a Ministry Joint Secretary, Ministry of Corporate Affairs, and another gentleman of Delhi. And of course, the returning officer is there, who is the secretary of the council. Now, my lord, rest, my lord, then if you turn over the page, for example, 67, you will find, my lord, that there are total number of 15 candidates for the council. My lord, we call it council and regional council. Council means central council.
Where are you seeing that?
My lord, dear lordship will see the council of the institute notifies that total number of in 67 will be 15. Has your lordship found that, my lord? And it will comprise of, from the western constituency, there will be 4, 5, southern 3, 3, and total is 15. And my lord, this is how it is to be done, my lord. Now contrast this with 68. Same day, elections are being given.
Yes.
My lord, you will find that for the regional council separately,
yes.
My lord, for western, there is 7, 11, 7, 7, 32. So, my lord, there are 2 types of election going on. One, my lord, is for the central, for the zones, as well as for the regions. Now, my lord, in light of this, my lord, having pointed because it will take a long time if I show you all the regulations, my lord.
Notifications.
Yes, my lord, notifications. Correct, my lord. Will you see the chart once, my lord? And please take it from me, my lord. It's there. my lord, the page numbers I've indicated.
Yes.
So, my lord, so I've showed you 68, page 68, 31st March 2000, separate notification, and the regulations I've mentioned. My lord, there are two, one is a rule and one is election rules, and another is regulation, that is the cost accountancy regulation. So 31st 69 will give you the constitution of, my lord, the 4 regional council. My lord, that is what is included. My lord, just have a look at 70, for example. This is another notification saying that Western constituency will consist of Chhattisgarh, Goa, Gujarat, Madhya Pradesh, Maharashtra, etc., etc. Has your lordship found, my lord? Yes, that is that notification. Then, my lord, comes 72. My lord, 72. Unfortunately, the rule has come in the second column while typing. My lord, it's a list of voters eligible to vote from various constituencies for election and 4 regional counts. So list of voters.
Mr. Bose, how is all this relevant
My lord,
for the
because,
finality and the irreversibility of the process?
Yes, my lord, kindly see the next last one. Last one is 30th April 2023. Last one, my lord,
Yes.
last one is it was published in the official gazette. My lord, this is the head and his name is excluded. His name is excluded. Now he says, after publication of these notifications,
Page 97.
97, my lord. Yes, that's a notification.
For a
That's the
volume
second
to-
volume. That's the
For a
second
volume to the
volume 2, volume 2. My lord, before that 92, the returning officer, my lord, publishes the name of the voters. In 92, it's not a notification. It's just name of voters. His name is also included in the Western. His name is included because that's, my lord, after receiving nominations, he informs in the website, these are the voters. But it is, kindly see the last, second last paragraph of that, my lord, at page, my lord, 97. My lord, kindly see 96. My lord, kindly see 96. It may be noted that the above details only indicated receipt of nominations in time. List of valid nominations shall be issued with decision from the panel of scrutiny of my lord at 96. It is subject to the scrutinizers giving this. And my lord, that has been done, my lord, in page 97. Now, my lord, page 97. Now, my lord, your lordship will find that 97, his name is excluded. And then, my lord, he writes a letter saying, look here, why has my name been excluded?
Yes.
Now, my lord, this is in this background, your lordship, his name was excluded. I give a reply also to saying that your name has been excluded because your name, you are a defaulter in 2000, since 2019 in the balance sheet because there are some dues payable. Now, the question which he tried to argue is that I was never informed, etc., etc. Now, he has annexed documents to show in 2000.
Mr. Bose, the point is only 2.
Yes.
One is whether there is any discretion in the matter.
Yes.
And number 2 is whether the process is irreversible.
Irreversible. Kindly see, my lord.
Yes.
Then what happens, my lord, in what he has done now, my lord, lordship was contemplating that why don't you allow him to pay and my lord.
472 or whatever the.
Yes, pay. Now, my lord, if you see 7, rule 7, this cannot be done now today.
Rule 7 as in?
Rule 7 of the election rules, my lord.
Which one? Which page?
My lord, if your lordship, my lord, the election rules, my lord, kindly see
72.
Yes, yes.
My lord, kindly see rule 7.
Yes.
Because, my lord, it says subject to provisions of these rules, a member who is fellow and his entrance fees and other dues are not in areas when on the first day of October of the year, my lord, it is admitted position is this, it is there. So if you ask him to pay it, this cannot be reversed. The same thing is in the voters list of rule 5, that the cutoff date is October 2022. So, my lord, this is the irreversible that you were a defaulter. Now, my lord, the Ahmedabad chapter, to which, there is a chapter, something called Ahmedabad chapter. Now, chapter is provided in bylaws, which again, has not been annexed. It has not been referred. There is something called a chapter, that each regional council can, under the bylaws, create a chapter. It can be a Calcutta chapter, Patna chapter, whatever he is of the Ahmedabad chapter files accounts. In those accounts, which have been filed from 2019 under the current liability section, his name is there as a defaulter.
Mr. Bose, the impugned communication, if I remember right, mentions either 11-12 or 12-11.
Correct. Impugned communication. Now see the impugned communication. Kindly the first annexure to the writ petition. This is not a gazette notification.
Page 32.
Page 32.
Yes.
It is mere communication. Now, my lord, kindly see page 32.
Yes.
And says your nomination has been, there's a duty, my lord, to communicate. My lord, it is not a notification. It is a mere communication. It says that your nomination has been rejected at its meeting held on 29th. And in terms of such and such, the reasons I'm giving you. Now, if you see the relief spread for in the writ petition, this is what he challenges. My lord, kindly see.
What is 12-11?
My lord, 12-11 of these rules, my lord, is the publication of the, my lord, kindly see 12-11 and 13-1-2, my lord. It's my lord, it's the after scrutiny.
So this is the communication only.
This is the communication only. And now see the relief spread for in the writ petition. My lord, I searched in vain also in the body of the petition.
What did you search for?
My lord, for the whether he has challenged the notification or not. Whether he has challenged the notification or not. And this is what is most important. The notification is as per the statute, as per the rules. You see the Constitution of India, this is valid until it is set aside. My lord, and there is no element of discretion, my lord, the valid rules are there. Just have a look, my lord, 13.3 small a, 13.3 small a, the Constitution.
Mr. Bose, are you sure? Because every time you're mentioning 13 is the consistent one.
Article 13,
what follows
13, I said 2, my lord, it says that, my lord, it's under part 3 of the Constitution, fundamental rights.
Yes.
It says state shall not make any law which takes away or abridges the rights under this part, and any law made to the extent shall be void. And my lord, in 3A says, what is the law? Law includes any ordinance, order, bylaw, rule, regulation, notification made under this force of law. Now, my lord, if you want aggrieved, you will have to challenge the notification. That's what I meant to say, my lord. You have to challenge the notification. And he is not challenged the notification. And
very well. That is all, Mr. Bose?
yes, my lord. And the other, he's saying I have to finish also. My lord, so about the discretion. Now, my lord, yes. Now, he has alleged malafide. He's alleged. Why?
No, he's saying that you have some other person who you want to be in the race.
My lord, I am not doing. My lord, I am the school council and the central committee. Now, he says that someone else, my lord, out of the 8 people are standing from the election. Out of the 8, one is the son of a chairman in the from the Gujarat probably panel, may not from the Western zone. May not. This is something. Let them sort it out. It's all India, may not, which is happening now. Sadhan, everyone's election would be stopped.
Very well. That is all. No malafide.
Yes.
That is all. Or you wanted to cite something?
No, my lord, I mentioned these rules that about the date October, my lord. I told you, lordship.
That is all. Yes, Mr. Shah.
Will you kindly have a look at, my lord, the rule, my lord, under which the communication is made? That is rule, my lord, 12 sub rule 11.
Yes, I've seen that.
Yes, my lord, lordship was told that this is only a communication, but my lord, it is the communication of the decision of the scrutineers that has to be, my lord, made through the returning officer. That is what is made. My lord, kindly, my lord, allow me to place rule, my lord, 12 sub rule 12 sub rule 11. In case where the nomination of, or if more nomination than one were filed,
all the nominations candidates such and such. Returning officer shall give notice of the decision of the panel together with brief statement for reasons. So, my lord, it is the returning officer who is, my lord, the spokesperson for the panel in the matter of communication of decisions. That's number one.
Yes.
Number two, my lord, your lordship will kindly see, my lord, just one document. My lord, this is the last annexure to the writ petition in volume 2.
Yes. Last annexure, that's in volume, which volume?
My lord, this is page 178. 178 and 179, the last two, my lord, pages of the writ petition in the second volume.
Yes.
My lord, this is, my lord, the subject matter of controversy. My lord, this, my lord, purports to be a debit note raised on 12th July 2019, being share of lunch expenses incurred for your representative election in 2009.
Mr. Shah, I can't hear what you're saying.
I'm
Yes.
sorry. My lord, lordship will see 178.
Yes, I've got.
My lord, this is, my lord, the debit note, my lord, which is at the root of controversy now.
Yes.
My lord, this is purporting to be, my lord, debit note raised for lunch expenses incurred by your representatives on election in 2019 of CCM, etc. 472 rupees. Now, my lord, without going into, my lord, whether this can at all constitute other dues, kindly see the dues, kindly see the next page. Post 179.
No, why are you saying this debit note is the bone of contention?
Because this is the 472 rupees that is purportedly outstanding.
That is fine. But is there any other angle?
No, I'll tell you, lordship, kindly see the next page.
Yes. Yes.
My lord, here, my lord. My lord, kindly see. My lord, there's a communication made to me on 19th August 2019. My lord, this is the second communication on page 179.
Yes.
In connection with trailing mail, we have not yet received the trailing mail first. My lord, at the bottom of the page, please find attached here with debit note for election 2019 share expenses. Then, my lord, next mail 2019. My lord, again, in connection with trailing mail, we have not yet received
No,
payment.
who is this Prajapati chap?
My lord, this is, my lord, treasurer of ICIA Ahmedabad chapter.
Yes.
It is from the Ahmedabad chapter.
That's
I
right.
have nothing to do
Yes.
with
No, my
this
lord,
interest.
my lord, then, my lord, again, the same gentleman, my lord, one PP Dave, executive officer of Ahmedabad chapter, writes, my lord, this was 17 July, on 19th August, he writes, in connection with trailing mail, we have not yet received payment against debit note. If you have made payment, kindly inform at the earliest. And my lord, then kindly see on the same date, this is my mail at the top of the page.
Yes.
My lord, my mail is, please send a person to collect check on Wednesday evening at 6 p.m. Now, my lord, there's a tender, there's an offer of payment. Now, my lord, no one has come to collect it, my lord, insignificant amount, my lord, that is something that, my lord, completely escaped everyone's attention. But, my lord, it can be a due only when, my lord, I have not offered to make payment. Today, I have offered to make payment, they have not come forward to collect. That's my lord, first submission. Second submission is...
Rule 5 and 7 talks of arrears.
Yes, now, my lord, kindly see, your lordship is absolutely right. Now, my lord, today, my lord, my learned friend is trying to give a different spin to this whole thing. Kindly see, my lord, again, the language, my lord, there is identical use of expressions in Rule 5 and Rule 7. To what extent, I'll show your lordship. My lord, kindly have a look at Rule 5 first.
Yes.
Well, at Rule 5, where's the rule gone? Yes, I'm sorry, my lord. My lord, Rule 5, my lord, this is the language. My lord, kindly see, my lord, entrance fees, annual membership fees, other dues. These cannot be in arrears, my lord, if your name is to be included in voter list. These are three expressions: entrance fees, annual memberships, and other dues. Now, my lord, kindly look at Rule 7. Identical. Entrance fees, annual membership fees, other dues cannot be in arrears. Now, my lord, I have already shown your lordship that, my lord, because there was no, my lord.
Other dues are not in arrears.
That's right. Because there were no other dues in arrears, my name was included in the voter list. But, my lord, nonetheless.
But why will this not come under other dues?
No, my lord, because, my lord, they had not, my lord, this is, my lord, not in connection with any, my lord, institute expense. This is, my lord, a lunch that, my lord, was, my lord, sometime, my lord, hosted in the time of election, then I had to pay for it. Because my candidate had, my lord, apparently, and I offered to pay. Now, my lord, when I offered to pay, well, it cannot remain in arrears because you have not come to collect it. When I offer, my lord, a payment and you don't come forward to collect it, my lord, I cannot be said to be in arrears. That's number one. Number two, my lord, it cannot constitute other dues because otherwise you would have not included my name in the voter list because these are other dues which are outstanding. And I've shown you, lordship, certificate of practice issued, my lord, clear check given, all fees paid, my lord, those documents I've shown you, lordship. Third thing, element of, my lord, discretion. Now, my lord, if your lordship will kindly see, my lord, Rule 12 once. My lord, scrutiny of nominations. My lord, kindly see, my lord, explanation 1
yes.
of, my lord, Rule 12.
Yes.
The panel shall not reject a nomination paper on the ground of a technical defect which is not of a substantial character. Now, it's not a substantial character. Now, here, if you also see, I've offered to make the payment. No one has collected the payment. But they're now using, this is a technicality that you're today disabled from contesting the elections because you have not paid this money. But my lord, I had tendered, and that is on record. And my lord, this is, my lord, even the description, my lord, that, my lord, there is, my lord, a play in the joints is even clearer from explanation 2. The rejection of the nomination of a candidate by reason of any irregularity in respect of that nomination shall not be a bar to the acceptance of another nomination submitted under Rule 9 and is also valid in respect of the same candidate. So, my lord, today I can submit another nomination. Now, my lord, my learned friends purport to refuse my nomination on the 30th of April and says that is the last day. So, my lord, we cannot alter anything. It's inflexible now. Kindly, my lord.
What about the challenge to the notifications?
No, kindly, my lord, see one more rule, Rule 4. Well, dates of elections. Now, my lord, your lordship will find, my lord, under Rule 2B, well, under Rule 2, my lord, there are dates prescribed. Last date of receipt of nominations, last date of scrutiny, etc.
Yes.
Now, my lord, G and H are, my lord, the two last dates, the date or dates of counting and the date of declaration of results. Then kindly see sub-rule 3. If, in the opinion of the returning officer, it becomes necessary to change for compelling reasons any date or dates notified under sub-rule 2, he may notify a fresh date or dates subject to the provisions of sub-rule 1 in the Gazette of India, provided that such a notification shall be issued at least 10 days before the revised date or dates, excepting for change in dates under clauses G and H of sub-rule 2. Clauses G and H are dates of counting, date of declaration. These two cannot be changed. Otherwise, all the other dates can be changed.
These dates are the dates of election.
Yes. Now, my lord, my learned friend says that, my lord, it cannot be now, lord, pushed back because, my lord, we have published the ballot papers. First is the date of, my lord, poll voting. My lord, then, my lord, 13th is the date of counting, so on and so forth. Your lordship has been shown. My lord, what I'm trying to tell your lordship is, my lord, first of all, my lord, the question would be, my lord, whether this answers the description of other area dues at all. My lord, because of the language, because my name is included in the voter list. Number 2. My lord, today when I've offered to make payment of the dues and that is on record and no one comes to collect it, whether it can remain a due in amount in arrears. Number 3.
Yes.
My lord, number 3. That, my lord, today, my lord, it is, my lord, something that is, my lord, not of a substantial nature. Yes. And, my lord, this answers the description of a technical defect, if at all, because, my lord, my learned friend says that because there's an amount outstanding, although it is absolutely insignificant,
yes,
you are disqualified. And, my lord, explanation 1 clearly says, panel shall not reject a nomination paper on the ground of a technical defect, which is not of a substantial character. My learned friend has conceded that, my lord, this is not of a substantial character. My lord, next. No, my lord.
My lord, I have not considered it is not technical.
Very well, my lord. Very well, he has not considered anything at all. But, my lord, my submission is, my lord, this is, my lord, if at all, a defect of technical nature, because, my lord, he says that there is something shown as outstanding against your name. And it's only a sum of 472, which I had already offered to pay. So, my lord, this is, my lord, not of a substantial character at all. And, my lord, number 4, there is, my lord, every opportunity for, my lord, the returning officer of the elections to, my lord, change the dates, my lord, unless it, my lord, refers to dates in, my lord, sub-rule 2, G and H. So, my lord, with the greatest of respect, my lord, today, my lord, kindly at the end of the day, my lord, let us, my lord, not, my lord, go into the question. My lord, what rule do I challenge? What notification do I challenge? My lord, do I have to, my lord, mount a constitution challenge for these things? I'm not challenging any rule. I'm not challenging any act. I'm not challenging any notification. What is the notification? Well, this notification is a notification which declares certain dates. The statute and, my lord, the rules appending to the statute clearly says that these dates can be shifted by the returning officer, by the election, my lord, committee. These dates can be shifted. If, my lord, there is, my lord, something that, my lord, ultimately turns up. And, my lord, here there is an attempt to, my lord, disqualify me at the end of the day for, my lord, a pittance, a demand of 472 rupees in August 2019, which I said, please come to my office and collect the check, which must have been the practice. No one collects the check. If I offer and you do not receive, then, my lord, I cannot be said to be in arrears. Arrears would have some other meaning. Well, these are my submissions.
Very well.
My lord, four sentences. My lord, first, my lord, I have showed one I have answered. I shall not reject nomination on ground of a technical defect, which is not substantial in character. Now, my lord, this is not a technical defect because it is hits against Rule 7(1). Then, my lord, the question that his other point, my lord, this is the main point, and he says no one came to collect. Now, whether he came to collect, I have been informed by the Ahmedabad chapter that he's saying, my lord, he has been informed that by the Ahmedabad the scrutiny that there is due pending, and my lord, in the books of account, there is money due and payable. So that's what he has done. The scrutineers have acted on that basis and informed that, but with a reason. See the particular letter.
Scrutineers still have a duty to see whether this is of a substantial character.
Yes, yes. They have a duty. They have thought about it and said, because the finance director has said, it's referred to that as by a letter that this is a due, therefore they have done it. You can see the letter. There's reference to a letter of the finance director also. You can check the notification. Then, my lord, the third thing, my lord, my name is in there in the voters list. Therefore, my lord, he couldn't have done this. Now, my lord, the answer to that again is there is scrutineers panel only for nomination. Nomination, that is Rule 12. I showed you. There is no scrutiny done for voters list. But even then, my learned friend should also say that, my lord, subsequently, there is a rule, Rule 6.2, my lord, which says that the returning officer can cancel even his name from the voters list. That is not by way of a notification, my lord, but by he can do it. And in fact, it has been done. My lord, kindly see.
They've said there are 0 dues owing from me in page 106.
My lord, now, whether,
what do I do?
Whether it is a no due, whether it is a substantial, my lord, they have regarded it as not a mere clerical or a irregularity. They have regarded it as a infraction of the entire rule. That is, cannot be done. This violation. Therefore, I said that you should have challenged the notification or the rule. This is something which is there in the statute.
Learned counsel appearing for the petitioner and the cost and works, what is it? Accountants.
Institute of Cost
and the institute have capital I have concluded their submissions. List this matter on 19th May 2023 under the heading for judgment.
Well, will your lordship want us to give a 1-pager tomorrow morning?
Not required. The more I look at notes, I get confused, so it's better not to look at. Yes.
Therefore, 1 page is it.